Okay, looks like the time to start. Good morning once again to everybody. Thank you to join us, to join this stream, and I hope you will find something interesting here today. I'm talking about and about speakers as well. I am Nikolay Melnykov, partner of Interlegal, and let me start and introduce today's event. I was born in 1972 at Soviet times, and I remember that style of living quite well. Then I remember Mikhail Gorbachev and turbulent times of perestroika. I finished my graduation at university and started my career as a lawyer at the turbulent times of Soviet Union collapse. Then I remember two financial crises, 1998 and 2008, and huge turbulence in the world and regional economics. 6 years ago, Russian Federation troops came to the Ukrainian land. It was unbelievable, and new waves of turbulence were started in our lives and in the Black Sea region as well. So I can say that turbulence is my lifestyle. And to be honest, I thought that nothing can surprise me again. But God thought in different way, and 2020 has started. And now I'm fully surprised again by the format and by the topic of our today event. But the spread of COVID-19 has become one of the biggest threats to the world now. At our event, we will focus on key pure shipping segments and also on procedures at courts and arbitration institutions in this period of time. You can see now the agenda on your screens. Please do it. Okay, so this is the agenda. And you can see that we have the top star team of speakers today. I wish all of you fruitful next hours. And I would like to say special thanks to Ince and personally to Julian Clark for supporting this event as an exclusive sponsor. Thank you very much indeed. Dear audience, very important, we're waiting for your questions during the event. Please use the special field at the bottom of your screen. So we can start, and our first speaker is Mr. Julian Clark, Global Senior Partner of Ince. Julian, floor is yours, or to be more correct, screen is yours. Good luck.
Thank you, Nikolay. Good morning, everybody. It's a real pleasure to have the opportunity to be speaking to you today. Of this fantastic conference. This is, I think, my second time of being lucky enough to speak and present at a conference for Interlegal. The first time I did that was a number of years ago. I can't now remember if it when I was at Clifford Chance or maybe Holman Fenwick Willen, but it was due to an introduction from my very close and dear friend George Zambartas. And I'm now delighted to say that not only is George still my dear close friend, he's also now my partner and the head of the new Ince office in Cyprus. So it makes this a very special occasion. I only regret that I can't be with you personally. I have 50 minutes to speak to you. And one of the challenges for me today was to decide with such an illustrious group of speakers what topic I should address you on over the next 15 minutes. And I've decided what I will do is speak to you about something which is very close to my heart in relation to the pandemic, which is the impact that the pandemic has had on seafarers and crews worldwide. It's clear, I think we all agree and we all know in shipping that seafarers are the key workers of the sea. But I think we also all know, all of us that are in the maritime sector, that despite the fact that the whole world relies on shipping, 90% of global world trade moving by water, seafarers on which we rely for our food, our medicines, our petrol, our energy, everything that comes via water, are largely invisible, and they've been so heavily impacted. So I'm going to speak about COVID and crew, but I'm also going to speak briefly about some contractual uncertainties and practical considerations. And in doing so, I hope I'm not going to steal the thunder of Soren and Valerio and Andrea, but I hope some of the things I say will form a foundation for what Soren will say about BIMCO's excellent clauses, Valerio, what he will say about crew and P&I cover, and Andrea about force majeure. So let's start by looking at some contractual uncertainty and practical considerations which we've experienced as a result of the pandemic. And let me give you an example of a case we were involved in, which interestingly was how the pandemic impacted on a sale and purchase deal. This was a sale of a Liberian flag vessel to a Marshall Islands buyer. The virtual closing was relatively simple. No problems at all in working through a virtual data room and organizing the sale and purchase without physically being present. But the problem arose when it came to the crew change. The buyer's crew couldn't leave Indonesia. The seller's crew were not allowed to disembark the vessel in Vietnam. And even if they had been able to do that, the Indian borders were closed. And the only place in which, or the closest place in which a physical crew change could have taken place would have been Korea, of all places. What did we do? Well, in this case, we managed to reach agreement with the buyers whereby they became the employers of the seller's crew. So there was no need for an immediate crew change. And that was relatively easy in this case because both the seller and the buyer wanted to complete the transaction. But it led us to think about what would happen in a situation where there'd been a substantial move in the market, where buyer and seller perhaps no longer wanted to do the deal. And what that raises is a number of questions. For instance, could a seller tender a valid notice of readiness under clause 14 of the Norwegian sale form if they were unable to disembark their crew and release the vessel free for the buyer? What happens in that circumstance if the buyers then refuse to pay the purchase price? Is that a default under 13? So clearly the best thing to do is to agree going forward. And as Dr. Fauci has unfortunately alerted us to, although we now have a vaccine, and obviously delighted to say that those vaccines started to be rolled out in the UK yesterday, as Dr. Fauci has unfortunately predicted, we are probably entering the age of the pandemic. So this is something which shipping is going to see in the future. And so I think it's important that we need to think about situations for all types of contracts. So in sale and purchase contracts, agreeing a termination, agreeing potentials for cancelling dates, looking at extending delivery ranges and who pays. But of course, it's not just sale and purchase contracts. Time charters have been affected by issues around the pandemic. Happens if a charter employs a vessel between ports which will not permit a crew change. Absent a contractual provision, going to a different port to facilitate that crew change may amount to a deviation. And I'm sure Soren will pick up on the BIMCO COVID-19 crew change clause for charter parties when he speaks to you shortly. Again, something that needs to be considered is how we deal with permission for deviation. And this is happening not always directly due to the pandemic, but as a knock-on effect of the pandemic. So many of you will be aware of the geopolitical position that's taking place at the moment between China and Australia, as a result of which a whole number of ships laden with Australian coal are waiting in anchorages off Chinese ports. And again, we're seeing a situation where we have a difficulty in relation to facilitating a crew change exacerbated by the pandemic. I'm just changing my slide, hopefully.
Yeah, no, fine. Okay. Yeah, no.
I've just got a slight problem on my slides at the moment, so I need to relaunch for a second because my screen is frozen. Bear with me.
17th of September. Okay.
So what happens, hopefully you can still see my screen. What happens if a vessel is ordered to a COVID-19 hotspot? Again, we need to think about contractual provision to deal with this. And again, I suspect that Soren will speak to you about BIMCO's excellent infectious and contagious disease clause and how that has assisted resolving disputes in relation to the pandemic.
Yes.
But let me move on now and talk to you in my final minutes in relation to the position which has faced our international crews. More than 400,000 seafarers on board vessels on commercial ships unable to be repatriated, long beyond the period of the contract, which is the maximum period of the contract under the Maritime Labour Convention. And on any given day, almost 1 million seafarers on 60,000 large cargo vessels worldwide. And as a result of the pandemic, we've seen a huge rise in mental health issues, isolation from the family and friends, inability to communicate with their support network, fatigue and frustration, lack of motivation, feelings of powerlessness, and of course, the inability to socially distance on board a vessel, which affects morale, but also affects, quite worryingly and concerningly, the attention span and concentration of crews involved in dangerous operations on board vessels. And this is something that I think we need to bear closely and carefully in mind. And it's organizations such as the Mission to Seafarers which have provided a helpline for seafarers. And the IMO, again, endorsing its 12-point protocol in Circular 4204, providing general to look after crew well-being. And I think it's extremely important that in these times, the maritime sector works together with the aviation sector. Again, unfortunately, speaking about that prediction of Dr. Fauci, that this will not be the last pandemic that we will see, and how this will affect shipping. Mm-hmm. We take the time after this pandemic to plan ahead, to talk to the aviation industry, to talk to international government, to work with the IMO and the CMI, to look at removing restrictions on visas, to create safe corridors for the transportation and movement of seafarers, to effect crew changes so that they are not exposed to periods at sea beyond the maximum period of their contracts as allowed under the convention, and to create better systems for testing, access to medical care and treatment. We've all seen the very disturbing and upsetting news in relation to seafarers that have been denied the most basic of human rights, medical aid in emergency situations as a result of the pandemic. And this is something that I feel very strongly about and feel that we as an industry, the P&I clubs, the underwriters, the brokers, the owners, the charterers, the traders, the lawyers, must all lobby for to ensure that we can protect these essential key workers upon whom we all rely. And if these problems are not recognized, we will see significant issues in relation to forced deviation. We will see delay, and we'll see a drop in general individual crew well-being, and also the negative effects that that has on the families. And although important, secondary to the mental health concerns of the crew and the well-being of their families, we do have to bear in mind the effect to our employers, our owners, for the adverse effect of media attention if crews are not protected properly. And I am going to take a moment, if I may, to give a plug for a campaign which I will be launching with Ince, but although we're launching it, it's not an Ince campaign. This is for our seafarers. So I would invite everybody on this conference, I know we're over 200 people listening to this, to email me for more details. I'm delighted to say that we have a cooperation agreement with the Mission for Seafarers, with the Maritime Museum, National Maritime Museum in Greenwich. And we're going to launch a song to bring awareness and hopefully raise funds for seafarers. I'm delighted to say that Rod Stewart has given us permission to record a version of his song Sailing. And what we're doing together with a film producer and filmmaker in Cyprus is we are going to take a film of crews around the world singing along to this song. And we're going to aim to launch that for Valentine's Day, another peak period where crews are isolated from their families and loved ones. So watch out for the announcements, please, of that campaign. If you would like to sing along, let me know. We'd be very happy to join as many people as we can in the campaign. But probably more importantly, when we do launch it, please share it so that we can raise awareness for the issues faced by our seafaring community, not only through the pandemic, but generally for those that are in peril on the sea. Ladies and gentlemen, that was an extremely quick run through, but I'm terrified of Nikolay, and he made it very clear that if I ran over 15 minutes, he would never be my friend or buy me a wonderful beer ever again. And my clock tells me that I've been speaking to you for 13 minutes and 39 seconds, so I think I've got there. Ladies and gentlemen, have a wonderful conference. I'm so proud to have been able to support this fantastic event. And thank you very much, and goodbye from me. Thank you.
Thank you very much, Julian. It was a great presentation. Thank you very much. You are right in time. You're the best speaker for now. Maybe you have some questions. You are free to write them in our chat, and we'll see your questions here. And I will have the honor to translate and to ask our speakers. Thank you once again. And the next, our virtual admin panel will go now to Soren Larsen, who is the Deputy Secretary General at BIMCO. Soren, can you just log in with your microphone? Do you hear us?
Okay. Can you hear me?
Can you close your sharing screen?
Yeah, it's closed.
No, yes. So now,
can you hear me now?
Yes, hear well.
Fantastic.
See well.
Thank you very much. Excellent. Well, let me first of all thank the conference organizers for the very kind invitation to join this online shipping and trade day. I vividly remember when Peter Sand, our famous shipping analyst, and I came to Odessa in 2018 for the Grain and Maritime Days, although it now feels like ages ago. The corona has completely turned our lives upside down. And corona is also what we're going to talk about within the next 10 to 12 minutes. Where I've been asked to provide you with a brief update on the BIMCO's COVID-19 related clauses. So Igor, if you can turn to the first slide, if you can find it.
Yes, here it is.
Yeah, and then the next one.
Yes.
Fantastic, because the three clauses I'm going to touch upon is and as Julian referred to, the infectious or contagious diseases clauses for voyage and time charter parties. I'll deal with those as one. And then, of course, it's the COVID-19 crew change clause for time charter parties 2020. And last but not least, BIMCO's force majeure clause. The latter, I have to say, is still in the making. We have engaged a high-powered working group with a view to develop a BIMCO standard force majeure clause And although it's not a corona clause as such, it is the coronavirus that sparked its development. So I thought I would bring that into the loop as well. As a practical note, I'm not going to share the wording of the clauses with you because they're all quite long, and I would vastly exceed the maximum number of slides that Igor allowed me to use. So he would get very angry with me if I exceeded that. But I know that he will be very happy to share the wording of certainly the infectious or contagious diseases clause and also the crew change clause with you after the presentation if you like to have a look. The force majeure clause I can't share with you because, as I mentioned, that's still in development. So on that note, let's kick off with the infectious or contagious diseases clauses, because after having lived a relatively quiet life since they were first developed in 2015, they all of a sudden became highly relevant again with the outbreak of the coronavirus that sadly turned into a pandemic. The clauses were developed in response to the Ebola virus. However, we decided at the time not to name the clauses after the Ebola, but to provide them with a more generic title so that they could be applied not only to the Ebola virus, but to other similar virulent diseases that may occur in the future. The working group that was involved in the development of the clauses deliberately set a high threshold for invoking the clauses so that they could only be triggered in the most severe cases of a virus causing a serious threat to human beings. And this was, of course, to avoid that they be misused for commercial purposes in relation to more, shall we say, commonly encountered viruses. So the question that quickly came to the fore after the outbreak of the coronavirus was, not surprisingly, was the corona series a serious enough virus to human health so as to enable the ship owners to trigger the clauses with all the consequences that may have? Considering the virus that the clauses were developed because of the Ebola, most people would probably say, no way is a coronavirus in the same league as the Ebola virus when it comes to, for instance, the mortality rate. But it is nevertheless a highly infectious, and in some cases, as we now know, it can cause extreme illness and be fatal to human beings. Whatever the right answer to the question is, we could see that ship owners were struggling to get the charters to accept the clauses if they already had them, if they didn't have them in the charter parties at the time of the outbreak of the coronavirus. And for those who already had them in the charter parties, the charters argued that owners had no right to invoke the clauses because the threshold for triggering the clauses had not been met with the coronavirus. If we could turn to the next slide, Igor.
Yes.
There we are. The next one again. You can see that's it. The purpose of the clauses is to give ship owners the right to refuse to go to an affected area. And that is an area where there is a risk of the vessel and crew being exposed to the disease that is highly infectious or contagious and seriously harmful to human beings. While, as I just mentioned, it can be argued if the coronavirus qualifies as a disease as defined by the clause, it can also be argued that the greater part of the world is now in an affected area. And that was not the case with the Ebola, which was more regional. So this is something that we are now going to have a look at to make sure that the clauses are workable in the situation we now find ourselves in. And if the great majority of charters feel that we have given the owners, and this effectively means the master, too wide discretionary powers to refuse the charter's trading instructions, well, then this is something we need to have a look at as well. So we have just begun a revision process, and we do hope to be able to present a revised set of clauses to BIMCO's documentary committee when it meets on the 25th of January 2021. As some of you would know, BIMCO's documentary committee is that big body of ship owners, P&I clubs, ship brokers who basically controls and governs BIMCO's contractual work. It involves some 65 to 70 people, so it's a big group of people involved in the process. So they will have a look at this, and then we will see what happens. Hopefully, we will be able to launch a slightly revised clause not long after the meeting. So Igor, let's move to the next slide, please. Because as Julian also referred to, in June this year, BIMCO launched a clause labeled the COVID-19 crew change clause for time charter parties. And we developed the clause in response to the extraordinary circumstances faced by many ship owners who had crews had to stay on board during the COVID-19 lockdown for periods often extending way beyond their contracts of employment. The clause provides for the owners the right to deviate, to undertake crew changes in specific situations, namely if the restrictions relating to COVID-19 prevent, and I do underline prevent, crew changes in ports where the ship has been ordered to call or within the scheduled period of call. Because the use of the word prevent sets a very high threshold for when owners can actually invoke the clause. The fact that a crew change at a port or place ordered by charters may be more expensive or less convenient is not a big enough excuse for the owners to trigger the clause and to go to that place to change crew. The clause is designed for use in longer term charter parties, not single voyage or trip time charter parties. And that's important because the use of the clause is predicated on owners not knowing at the time of the fixture the place where the ship will be traded by charters and all the travel restrictions at the time when the crew change becomes due. The clause was drafted specifically in response to the first COVID-19 outbreak, but it can also be applied to any second wave of the virus, as we are confronted with right now in many parts of the world. In addition to giving the owners the right to deviate for crew changes, which would otherwise be prevented from the COVID-19 restrictions, the clause provides an option for the charters to contribute to crew changes in view of the potential significant cost in order to deviate, to make a crew change related COVID-19 crew related change. The charters can do so by agreeing to let the ship remain on hire at a reduced daily rate, as agreed by the parties, and they can share the bunker cost on an equal basis with the owners. I should be very honest with you and say that the clause caused quite some discussion within BIMCO's documentary committee, which represent both ship owners and time charters, and some acting in both capacities. Not all time charters could see the rationale in them having to contribute to something that until now has always been an owner's matter with the ensuing cost, no matter the circumstances. Nevertheless, with the great assistance of a super engaged subcommittee involving the P&I clubs, we managed to develop a clause over a course of 14 days. And that was adopted by BIMCO's documentary committee using our fast track procedure. It's very, very important to emphasize that the guiding notes to the clause makes it crystal clear that on each and every occasion, the owners intend to deviate for the purpose of crew changes under these circumstances. They must first consult with the P&I club to ascertain that the deviation will not prejudice cover. It is vitally important. The feedback we have had today suggests, and I think that was also indicated in Julian's one of Julian's slides, is perhaps not surprisingly that it has not been taken up at any great level, if I can say that. Certainly, as far as the charter's contribution to the cost is concerned. Very few charters have agreed to that, but parts of the clause have been in use, and that's the one that basically gives the owners a right to deviate without necessarily being in breach of their contracts. So as I say, bits and pieces of the clause being used, but in totality on a very limited basis. I think you would need to know your time charter pretty well in order to agree on this. And that leaves me with the last COVID-19 related clause, which is BIMCO's force majeure clause. It is perhaps not surprising that the concept of force majeure has been on many people's lips since the outbreak of the coronavirus, because some contractual parties, not saying all, have seen an opportunity to get out of the contracts or to be excused from performing because of the problems caused by the pandemic. Force majeure has, for example, as what we have seen at BIMCO at least, been claimed with a view to avoid liability for delays caused by closed ports and imposed quarantines. As you will see, and as you will know, under certain laws, if you don't have a force majeure clause in your contract, you will be in breach if you cannot perform, even if the reason is a force majeure type event. And that's because under certain jurisdictions, for instance, in the UK, not having a force majeure clause means basically no force majeure. Under French law, I'm led to believe you will be able to rely on force majeure even if you don't have it in the contract, because it is in the law. Now, BIMCO does not have a freestanding force majeure clause in its clause library that can be inserted into contracts. We created one for supply time, which is the most widely used standard contract within the offshore sector several years ago. And that has also been used in some other BIMCO contracts. But we never had a standard BIMCO force majeure clause as such. That's now going to change because it was felt that with the corona, time had come to develop a BIMCO standalone clause that can be considered for inclusion in some very important contracts that BIMCO is currently revising, which is GenCon 94 and the associated BIMCO GenCOA, General Contract of Affreightment. We do hope that these revised contracts will be ready for adoption by BIMCO's documentary committee in May 2021. And the force majeure clause that we are now developing may form part of those contracts. I can't say it will happen for sure, because that's up to the documentary committee, but we must at least have the possibility to include them. So the target date for this clause will be May 2021. I'm not sitting in on the subcommittee that's drafting the BIMCO force majeure clause, but I'm told that it will contain a high threshold for invoking it. So you can see that BIMCO is very much into applying high thresholds. And that is, of course, because BIMCO does not want to publish a clause that can be easily abused by the parties to rescind the contract that has turned out to be less lucrative. And certainly when it comes to force majeure situations where the consequences can be phenomenal, huge. So to come within the clause, you need to have, because the drafting group has actually presented a first draft, and they're actually going to meet again very soon to continue its work. But I know from the clause that you need to have been prevented from performing an obligation under the contract, and you will need to be able to demonstrate and that you are the force majeure event was beyond your control, that you could not have foreseen the force majeure event at the time you entered into the contract, and that you could not have avoided the consequences of the force majeure event. Although not a force majeure requirement as such, the party affected by the force majeure event will need to give written notice of the force majeure event to the other party without delay, identifying the force majeure event and the anticipated effect it may have on the performance of one or more of the contractual obligations. That's very, very important. The clause contains a long list of events ranging from the traditional events you would find in a force majeure clause, like natural disasters, explosions, fires, war, piracy, etc. But it will also contain some new ones, like, for instance, cyber attack. And then I think it's safe to say that there will be a reference to pandemics as well. The main consequence or remedy for the party invoking the force majeure is that it will not be liable in damages for breach of contract if it cannot perform because of a force majeure event. But there will be a right to terminate the contract if performance becomes impossible or something completely different from what was intended by the time the contract was entered into. But termination should, of course, never be taken lightly, and it should always be the very last resort, and it is only available in a limited set of circumstances. I'm getting to the end now, but let me just say that the question remains, the standard force majeure clause that BIMCO is now developing, will it be a one-size-fits-all, that clause that can be incorporated into a number of different types of contracts as is? The answer to that is highly likely going to be no. It's still to be fully decided by the working group and ultimately the DC, but the answer is likely to be no, because it will simply be too complicated to develop a clause that would fit all the different types of contracts where there may be a need for different types of consequences. For instance, the consequence of a force majeure under a ship sale and purchase contract may be different from those under a voyage charter party, for instance. So what we're going to produce is a general force majeure clause that people can adapt to their specific type of contract with bolt-on provisions as may be needed. So this ends my quick run through of three COVID-19 relevant clauses. I could only give you a relatively brief overview within these 10 to 12 minutes, but I hope you at least now a little bit wiser in terms of where BIMCO is when it comes to these types of clauses. And I do apologize, Igor, if I overran my time. But anyway, thank you so much. And it's really good to see you all out there.
So, thank you very much.
Hope to see you in person one day.
Thank you for an enormous job that you do at BIMCO. Thank you for your time. We are always happy to hear you and see you offline and of course online during these strange and turbulent times. Of course, all our participants will have the follow-up letter with all the presentations, so everybody will see all these ideas regarding clauses and all your great job. Thanks a lot.
Fantastic. You're welcome.
And now the time of the Daniella Horton. Daniella is Honorary Secretary and full member of the London Maritime Arbitration Association. Hello, Daniella.
Igor, good morning. Thank you very much for this opportunity to once again speak to your audience. I too have very good memories of being in Odessa in 2018. And so it's a great pleasure to be with you again this morning. So, друзья, коллеги, доброе утро. Good morning, everyone. What I would like to share with you this morning is what I believe is a silver lining that has come out of what has otherwise been an incredibly difficult and cruel year for so many. So, there's an old sailing phrase that goes along the lines, it's an ill wind indeed that blows no good at all. And I would like to put to you that what's come out of this year as one of those minor goods, one of the true positives, if you like, that's come out of this year is the innovation of virtual hearings in arbitration. Whether these are called remote hearings, virtual hearings, I understand they're now being called visible hearings. Whatever the terminology, the fact is that they have they've come out of this year. This innovation all happened incredibly quickly in a matter of weeks in March, and I believe they're very much here to stay. So what I would like to do today in my time available is just to look a little bit at oral hearings and the movement to virtual hearings, how the innovation took place this year, what our new normal is, and then a few predictions, a few ideas for the future going forward. So the first point I'd like to make is that not all cases require an oral hearing. It's perfectly safe for many cases to proceed on the documents without any oral hearing, without any live hearing, if you like. But almost all arbitration rules that I'm aware of will make some provision for an oral hearing. Now, the UNCITRAL rules succinctly explain what an oral hearing is likely to be for, namely that it will be to hear the evidence of witnesses, to hear the technical evidence of the experts, where this may be better explained in person than on the documents alone, and to hear the advocate's oral arguments. Now, as for the circumstances of how that oral hearing will come about, both the UNCITRAL rules and the ICC rules will provide that there will be a hearing where the parties requested, where either of the parties requested. So it doesn't rely on the parties agreeing, it's simply a matter of either party requesting. Now, I'd like you to look just briefly at the ICC rule wording that I have put on the screen, namely that the arbitral tribunal shall hear the parties together in person if either party requests it. I'll be coming back to that a little bit later. Oral hearings are incredibly valuable. However, they come at a cost. That is that the cost of bringing your advocates, your lawyers, your witnesses, all to an oral hearing can, and often is, I'm afraid, quite expensive. As a result, in the LMAA terms, the starting point is it possible for the parties, for the case to proceed on the documents alone? And so what the LMAA terms do is, rather than offering the parties the option of requesting it, what they do is they ask the parties, is it necessary? And if the parties decide that the reference shouldn't go on documents alone, then the tribunal will look at the evidence and decide what is most useful, whether to have an oral hearing or not. And as a result of this, hearings in LMAA cases are not the norm. In fact, 20% of cases will generally go to an oral hearing. And that means that roughly per year, 100 cases will go to an oral hearing. So that's the background. And then, of course, came the dilemma in 2020. What to do? Suddenly, oral hearings were not a possibility. And both the LMAA and the arbitral world worldwide was faced with this question. Do you simply allow those cases that require an oral hearing to be delayed indefinitely? Or do you embrace the technology that's available? Now, I think at the beginning, that was a very perhaps concerning, even scary thought for a lot of people who had not previously had availability, access to this technology. The LMAA were very quick to decide this point in favour of embracing technology. The then president, Ian Gaunt, very much encouraged arbitrators and the users of arbitration, the parties, the advocates, the barristers, and so on, encouraged embracing technology and moving to virtual hearings. This was very much endorsed and followed by the arbitral institutions, who issued a joint statement in April of 2020. And that statement very much encouraged, again, tribunals and parties to embrace the available technology, use the procedural tools they had available to them to avoid delay. And so then out of that, the LMAA, and indeed followed by other arbitral bodies, produced guidelines for how to get the most out of your virtual hearing. The details of that guideline are on the LMA website. I'm not going to go through it in detail today. I'm simply going to highlight really the one key point that comes and threads throughout the document, and that is one of preparation. Because you're going to have to ask yourself questions that you won't have had to ask before. So for example, what virtual platform will you be using? What document management system will you use? Will you need somebody to help you with that? Again, those questions are beginning questions. They really need to be addressed at the beginning of the procedure. During the course of the procedure, another large element, a key element of preparation is the bundling, the documents. So very often now you will have an electronic bundle sat alongside a physical hearing bundle. And it is absolutely critical that things such as the numbering are identical. These are small points, but they are points of preparation that if you don't get right, they can really cause problems within a hearing. If you do get them right, then things run smoothly and efficiently. Another question, for example, how do you introduce new pages into your electronic bundle on the day of the hearing? All of these things are not insurmountable, but they are issues which require preparation. Another question, how many screens do you need? For example, very often you will want a screen to look at the speakers, a screen to look at the documents. You may then want a screen for the live transcript. The last key point about preparation that comes out of the guidelines is you must have a rehearsal. You must test your equipment, and that means that everybody involved should test their equipment, and they should make sure that they have connectivity, that they can be heard and so on, and also have a backup. Because the last thing you want is to have, for example, 10 people involved in a virtual hearing, and to then find that one person caused this whole thing to stall. So that key message there is preparation. So out of this, there's no question that virtual hearings are practically possible, but there are a couple of fundamental questions which you must also address before committing to a virtual hearing. The first one of those is it legal? Does the place of the arbitration, where your seat of your arbitration, your place of your arbitration, does it allow virtual hearings? Now, I'm only aware of one case so far that's gone through the courts. That was in Austria. And the Supreme Court in Austria earlier this year held that even where one party opposes, ordering a remote hearing is admissible and will not constitute a reason to challenge the tribunal. So, assuming that you're okay as a matter of law, what do the procedural rules say about virtual hearings, if anything? Now, this issue came up in relation to the ICC. Now, you may recall just a little earlier, I referred you to the wording, the precise wording of Article 25, which said that the arbitral tribunal shall hear the parties together in person. Now, very early on in 2020, the question was raised, well, does a virtual hearing, electronically, digitally, does that come within the framework of hearing the parties together in person? Now, the ICC were very quick to confirm that it did. It issued a guidance note in April, stating that this language of Article 25 can be construed as referring to the parties having an opportunity for a live adversarial exchange and does not preclude a hearing by remote means, by virtual means. In addition, the ICC, in order to make this absolutely clear, have amended, as part of their amendments of their rules, which will be published in 2021, in January, I believe, they have added an express provision to Article 25, and that is that the arbitral tribunal may decide that the hearing can go ahead by various means, by remote video conferencing, by telephone, other appropriate means. Similarly, the LCIA changed or amended their terms earlier this year in September, and they also made express provision for video conferencing and virtual hearings by various means. Now, the LMAA took a rather different view on this, and back in 2016, the idea of at least semi-virtual hearings was already in the minds of the drafters of the 2017 terms. And so if you look at the LMAA questionnaire, which appears within the terms, that invites the parties to consider whether all factual witnesses and experts need to give evidence in person, or whether it's either necessary or desirable for some witnesses to give evidence by video link. And so in that sense, this is something which the LMAA already had in mind, at least in part. So what to the future? My suggestion to you would be that virtual hearings are very much part of the arbitration landscape to come. Hopefully life will return back to some element of normality, such that this will be a preference or a choice rather than the current position of it being a necessity. But nevertheless, I think you will find that a lot of people will choose it. I think one of the feelings we have from the feedback the working group has received is that in future, once a live hearing is once again possible, that hearings are likely to take a semi-virtual or hybrid format, i.e. you may have the tribunal in a hearing room. They may, for example, be joined by the advocates in London, but it may be then that the parties, the lawyers, the witnesses will all join remotely. It seems to me there's also a possibility that this may increase the number of the number of oral hearings in the future, because very often, I talked earlier about oral hearings being expensive. And if the expense is reduced by not needing to bring in the witnesses, overseas lawyers, parties, if all of those people don't need to travel and the expense is reduced, then it seems to me some of those cases where there may have been a borderline view of, well, shall we proceed with oral hearing, or is documents enough? I think probably in the future, we may find more of those borderline cases resulting in an oral hearing. It also seems to me there's a possibility that there may be a revival of what used to be the interlocutory hearing to decide on directions or the procedure of an arbitration, which in latter years, again, because of cost primarily, has fallen by the wayside, so that at the moment, procedural matters are generally dealt with purely by exchanges in writing. And it seems to me that possibly in the future, we may start to see procedural hearings becoming more the norm again. The whys, I think, are obvious. The pure efficiency of being able to do something from your desk rather than to travel. The obvious financial savings that are gained by a virtual hearing. And a third point is that it makes the whole process, obviously arbitration remains confidential, but it makes it much more accessible to all of the people involved in that arbitration. So not just the tribunal and the lawyers at the hearing itself. It means that the parties, perhaps who wouldn't otherwise travel to the hearing, can view the virtual hearing. It means that parties such as the insurers, who are funding very often the arbitration, but wouldn't normally attend in person, they can also view it. So really, to wrap that all up, I think that the innovation is one of the few rays of sunshine that has come out of this year. I believe it's here to stay, and I very much commend it as a way of proceeding for those who are considering it. Thank you very much.
Thank you very much, Daniella. Let's hope for the best, and let's hope that instead of our virtual meetings and virtual hearings and virtual Zoom, we'll have a pleasure to see one another next year or maybe somewhere else. Thank you very much for your time.
Thank you.
It's my pleasure now to pass the word to our partner Natalia Myroshnichenko. Natalia, you are in.
Good afternoon, colleagues and friends. I'm so glad to have all you here. Of course, virtually, but nevertheless, we are all together. And best greetings to our brilliant audience from all over the world. It's a great opportunity, actually, to gather all these people in this format. I'm Natalia Myroshnichenko, the partner of Interlegal, and first of all, I would like to wish my partner, author Nitzevich, the soonest recovery. And actually, I would like to start with our very, very pleasant event which took place just a week ago. And I would like to congratulate, first of all, author Nitzevich as the founding partner and all my partners with our great anniversary of 25 years of our practice. All this time, you know, we are specialized in transport, shipping, and trade. And you see some figures about us. But actually, what is the main point in our practice is that we are Black Sea law firm, having our own professional network on the Black Sea shores and in all Black Sea countries. So now I would like to give just a very short review of our this year, very surprising, I would say, experience in this area. You know that usually Black Sea is a quite a good region to make the vessels arrests. How sad it can be sound for the ship owners. And this year was not surprising in this regard, because still all these jurisdictions, you see the table here of all Black Sea countries, all these jurisdictions are very good platform to secure the creditors' claims in respect of the vessels and the ship owners. Yes, the rules differ from country to country, but considering the geographical position of Black Sea, and usually sometime that the vessel should spend in any of Black Sea port, so it's quite a good chance for the creditor to arrest. This year we have made about 20 arrests in Black Sea, in different Black Sea ports. Of course, if we are serving for the vessel owner, it means that we can release his vessel quite quickly. That is very important. Talking about ship owners and our assistance for them, I would like to share our great experience of this year. We have made huge analysis and huge analytic works as for the grounds and legislation base for the ecological service scope of authorities. And I believe that our work was also a great input for the country in whole, because somewhere in the middle of the year, our legislation has been amended considerably in this regard, and the scope of authorities of ecological service has been limited and has been clarified very much. So during the second half of this year, I believe that the ship owners have not faced so much pressure from this ecological service as before. However, I would like to say that this struggle or fight is still going on in some ports with some inspectors. So we are here. We are ready for the assistance of ship owners anytime, 24/7 a week. This 2020 year was actually quite good for S&P deals, sale and purchase of vessels in our region, because this situation, including pandemic and the freight rates, does not give more opportunities for some vessel owners, and they were forced to sell their fleet. So we were involved in these deals quite actively. And of course, still of very high demand is our work about the search and due diligence of local entities, of local people. I mean, not only Ukrainian persons, but also all the persons from Black Sea countries. Having our offices in these countries, we can easily trace as a company or a person in order to understand if the recovery is possible or will be effective. And our yacht practice, I cannot be silent about it. You can understand that this year was not the best year for this practice, and of course it was a lockdown starting in March and ending still maybe in June for some countries. Of course, yachting was very much affected because the borders just were closed. But nevertheless, in the second half of year, it was a very quick recovery, and because people love their yachts and they would like to use it. So still we are here to assist our clients with full range of services for yachting, starting with registration and ending with commercial use of big and mega yachts. I think that that's all review for now, and we are, as I told, 24/7 for client supports, and of course we also are very glad every time when our colleagues reach us with some request or just asking for assistance or answer the question. We are always ready to do it, you know, my friends, as well as our team, our international team of partners in Black Sea countries. I'm proud to be the part of this partnership, and some of them are here today with us. Hello, everybody, my partners. So we continue practicing And our mission is to be useful for the fair business of our clients and for our colleagues who also assisting the clients in this quite interesting and quite surprising times. Thank you so much for your attention, and I'm ready to answer the question online if you have some.
Yeah, we have two questions from anonymous participants. Have there been any disputes related to pandemic in your practice?
A very nice question, and it's quite in time, because I would like to say that directly issues connected with pandemic have not been here in place with us. Because, as you know, our usual practice for Ukrainian exporters is their disputes under GAFTA and phosphor contracts, and no official lockdown was announced for the transportation of goods, only for the transportation of passengers. So all our logistics chains were working properly here. Ports were working properly. That's why no claims with regard to some restrictions or for the export, for loading, for delivery of goods. And the same for charter parties, because the vessel were not anyhow detained in our port, as well as in any other country of Black Sea region. That's why I would say that only indirect claims or disputes took place, but not quite rare. Maybe something connected with container carriages, especially importing from China, and at the early beginning of pandemic lockdown, like in February or March, when offices in China were closed and just did not answer. So that was the nature of the disputes.
Okay, thank you, Natalia. Thank you very much. And we have to go on. And now we have some interesting speech from the George Zambartas and Vasiliki Malta from Ince, from Cyprus directly. Hello, George. Hello, Vasiliki.
Yeah, hi. So Lydia's going to give us an introduction before we come in. So she's not doing a Zoom bomb. Don't worry. Okay.
Okay.
Over to Lydia.
For the benefit of our Russian-speaking participants, I would like to introduce our speakers in Russian. George Zambartas and Vasiliki Malta will discuss a ship detention case they were involved in during the COVID crisis, which at the time appeared to be mission impossible. Меня зовут Лидия Руси, и я недавно стала частью команды Ince на Кипре. Прежде всего, мы хотели бы поблагодарить Interlegal за приглашение на этот вебинар. Эпидемия коронавируса, конечно, оказала определенное влияние как на нашу работу, так и на судоходную промышленность в целом. Мы заметили негативное влияние COVID в рядом случаев, но именно задержание корабля, о котором Джордж и Василики будут сейчас говорить, на наш взгляд является самым необычным и может даже послужить сценарием к голливудскому фильму, такому как «Миссия невыполнима». Спасибо.
Well, thank you, Interlegal, for inviting us to participate at this conference, and thank you, Lydia, for that very kind introduction. So, during the height of the COVID crisis, we were instructed to deal with a rather interesting and unconventional case, weren't we? And in fact, it was during, I think, our first lockdown in Cyprus earlier this year.
Yes, that's correct. It was during our first and most severe, if you like, lockdown that we had here in Cyprus. the preventative measures that were taken by the government were indeed very strict. We were only allowed to go out 3 times per day, and only after we obtained an approval to do so by sending a message to the government by SMS. And the reasons that we could use in order to go out were like for a visit to a doctor, pharmacy, grocery shoppings, or to help someone in need. Of course, this didn't include going to work. We remained open, fully operational, and we tried to provide our clients with the best service possible under the circumstances. Among other governmental departments, the courts were closed at the time, and we couldn't appear before the court unless the case was really urgent. And only after we submitted an application to obtain an exceptional leave in order to be able to appear before the court. So this case, George, was about a ship mortgagee who obtained the ownership of the vessel by enforcing a share pledge, isn't it?
Yes, that's right, Vasiliki. Basically, we were instructed to protect the position of the owners because the vessel was in port in Limassol and prevent a potential act of piracy due to the fact that the master and the crew were not complying with the instructions of the new owners and managers, but instead were only cooperating with the previous owners. And there was a real concern that the master and the crew would sail the vessel to a port of their choosing. They would abandon the vessel and disembark due to the very strict COVID restrictions that were in place at the time regarding disembarkation. Indeed, it was certainly a major factor that the master and the crew believe that they may be trapped on the vessel indefinitely because of these restrictions.
Yes, and we also sent formal letters to the master of the vessel, but we received no reply. We then applied to the court to obtain an exceptional leave to proceed and file an application to arrest the vessel. The plan was to arrest the vessel based on the default under the mortgage, notwithstanding the change of ownership that was affected by enforcing the share pledge. Well, unfortunately, our application was somewhat absurdly rejected by the court on the basis that this wasn't urgent enough. And I remember that day, the secretary of the judge called me to announce me that our application was rejected. And I remember that I asked her if they're going to reply to us back in writing, because we needed something in writing to show to our clients. And she said that they wanted basically that was our reply in the phone call.
Yes, that was really disappointing at the time. If an arrest is not an urgent matter, I mean, what is? And the vessel was due to leave Limassol the next day.
Exactly. Following the rejection of our application by the court, the position was looking grim. So we turned to the port authorities, but they informed us that they had no authority to intervene, and they asked us to turn to port police or the DMS.
Yes, and when we consulted the port police, they said that they could not intervene either without a court order or unless there was an endangerment to human life, which we could not establish. So basically, we're just going round and round in circles.
Exactly. And then we struggled again because of the COVID restrictions at the time, because the DMS, all the relevant departments at the DMS were closed. And when we finally managed to get hold of someone at the DMS, they initially informed us that they couldn't assist because this was a private matter between the ship owner and the crew, and that without a court order, they were powerless. And then what did we do, George?
Well, we had one last hope, which was a rather unconventional route. The managers advised us that the Maltese registry had suspended the flag of the vessel due to the withdrawal of the Safety Management Certificate, the International Ship Security Certificate, and the Maritime Labour Certificate. So the vessel was in contravention of the ISM Code and the Maritime Labour Convention.
George, if I am not mistaken, it was you that located the then Deputy Shipping Minister and persuaded her to intervene, isn't it? And by the way, I remember that everything was happening just a few hours before the departure of the vessel from Limassol port.
Yes, that's correct. So then Deputy Shipping Minister is actually the wife of my cousin. And we needed desperately to get hold of her. But this was very difficult. Because of the COVID restrictions, she wasn't working in the offices of the DMS. So I called my cousin on his mobile and I asked him where his wife was. He replied, well, actually, they were at home. They were in the garden together. So I said to him, well, can you pass her the phone so I can speak to her? He did. I explained the situation. I described the circumstances regarding the suspension of the flag. I emphasized how urgent and desperate the situation was. The clock was certainly ticking and the whole situation was becoming very, very tense. But the Deputy Minister agreed to help and she agreed to get in touch with the relevant person at the DMS that could move matters forward. But there was still a lot to be done. And you contacted that person at DMS, didn't you? You spoke to him, Vasiliki.
Yes, that's correct. I explained to him the whole situation, basically with the certificates and that the vessel couldn't leave the port. I even sent him the letters we received from the Maltese registry. Mr. Barnavidis, who was the responsible person at the DMS, explained to me that he totally understood the situation, but he couldn't proceed unless he had the written confirmation by the Maltese registry. We remained in contact the whole time until he received the written confirmation, and immediately he issued the prohibition of sailing. And just a few hours to spare before the departure of the vessel from Limassol, we managed to detain her.
So the vessel remained detained in the port until a solution could be found between all the parties concerned. And like all good Hollywood movies, when the tension was at its highest, when all hope seemed to be lost, it needed heroes to intervene and save the day. In this case, legal heroes that turned mission impossible into mission accomplished. That's it. Thank you very much for listening.
Thank you.
Thank you very much, George. Thank you, Vasiliki. It was very interesting and very not boring. So I hope everybody was greatly surprised by your such a creative presentation. Thank you. And now is the time of Anthony Desbrousses from Marine Recoveries, United Kingdom. Anthony, are you with us?
Oh, can you hear me?
Yes, yes, hear well. Great.
Good, excellent. Thank you very much to Interlegal for giving access to this wonderful event and share a few views on those important topics. I'm going to try to share this presentation, which I hope will work. Can you actually see my screen now?
Not now, no. Try the green share screen button at the bottom of the screen.
Yes, here we go. That should do.
Yes, now we see your screen. Yes,
excellent.
Great.
Thank you. Thank you very much. Let's put this in a nicer format if possible. Right. So the task really was to discuss the impact of COVID on the subject of cargo recoveries, which are never an easy task anyway, but COVID seems to come on top at the moment. So this is really something to look into. And amongst various issues, it became very clear that because there is less traffic, there are less claims, and therefore there are less recoveries. So it becomes very, very important for all cargo recovery agents to bring more added value to their customers, and therefore help them facing different issues which they will have when they deal with their own insurers or the liability insurers of the sea carriers. So we will see that for a start, and then we will see how those elements can be varied with the crew element of the seaworthiness of a vessel. We will also see how COVID-19 can be used as a camouflage when some ship owners are facing other liabilities. We will touch on the crisis management, and finally we will look at the role of P&I clubs at such a difficult time for ship owners. So on the cargo side, cargo interest will face a loss due to delay, for instance, and they will turn naturally to their closest friends, who are the cargo insurers. And that's when they will realize that actually those delay risks are not necessarily well covered. And very often they are effectively excluded. When you look at the most the standard ICC clauses, and also the most recent views taken by the Lloyd's Market Association, it becomes clearer and clearer that those risks are excluded under the cargo insurance policies. So the next step for a cargo interest will be to look at the ocean carriers. Now, the ocean carriers very astutely will call upon their P&I clubs to help, and it will be very clear very quickly that under the Hague dispute rules, all those delay claims, particularly the quarantine delay claims, will be rejected. So effectively, you have a situation where the cargo interest cannot get compensation from his own cargo insurers. He cannot get compensation and indemnity from the carrier. He's therefore on his own. So the big question for the cargo recovery agent is, how can he bring some added value? Well, that's possible under the angle of the ship's seaworthiness, or rather unseaworthiness. And of course, we have in mind at this important time the crew element of the unseaworthiness. So we know that a ship owner is supposed to make his vessel seaworthy, including from the point of view of the crew at the commencement of the voyage. And we are going to see an interesting exercise, because this duty can be fulfilled differently. We've got to decide how to assess the quality of the delivery by the ship owner. And it goes without saying that because the pandemic has evolved, scientists have not always been able to give guidelines. We only see them coming very recently, and therefore the prudent test owner should evolve as well. There will be an evolution with time. I don't think we can blame a ship owner for not fulfilling his duties in the same way now as we would have done 6 months ago, for instance. So there's got to be a lot of work on the part of the cargo recovery agent to assess what was prudent or not prudent at the time when the ship was ready to sail. And of course, we will have the old issue about documentation. How shall we expect ship owners to document all their efforts, and shall we have access to that? So as cargo recovery agents, it becomes very clear that the crew seaworthiness is a key factor to look into. The next hurdle for cargo recovery agents will be to check whether the COVID-19 is used as almost like a camouflage decoy for other liabilities. We have situations, for instance, where, yes, there is a COVID-19 issue, a ship is delayed or deviates to a port, but actually, when you look deeper, you find that there may be other problems beneath. And this is not a surprise, actually, because the vessels have problems all the time. And even before COVID, they had all sorts of issues which made vessels get delayed. So it's really important for the cargo recovery agent to be able to pinpoint the cause of the delay and not just take COVID-19 for a convenient excuse. I would also recommend that all cargo recovery agents give precise notice to the carriers about which document they need, and that's so that the disclosure exercise can take place later on. And in this modern age, I think it goes far beyond the usual logbooks and all those documents, which can be conveniently filled anyway. And I think it's important to remind people that they need to keep safe any social media, any email, any correspondence. That's WhatsApp and equivalent. The question for recovery agents when pinpointing the cause of the delays is also how to access a ship. And we've seen that a lot. And all the webinars you attend actually mention this. How do we access a vessel? In normal circumstances, an ocean carrier is not likely anyway to give access to some cargo surveyors or cargo recovery agents. It becomes worse in times of COVID-19. Assuming you are allowed to go on board, you cannot even fly into the country, or you get quarantines or delays. So that becomes a real issue. And we also have the situation where multiple causes are observed. So there would be a delay, for instance, and there would be a COVID-19. So it's about apportioning those factors. A cargo recovery agent also has to be able to bring some input in times of COVID-19 when it comes to the management of the crisis. We start from the point where a ship owner, of course, has a duty to look after the cargo over the entire voyage. Then the ship owner will say, well, actually, there is an exception here. I can exclude any liability. Look at Article 4, for instance, from the Hague Dispute rules. So this is really, again, we are back to this point where the ship owner has to prove that his vessel was seaworthy and ready for the intended journey. So that goes back to the core of the problem, which is the collection of evidence. A cargo recovery agent should also, when there is a crisis, make sure that he underpins his recovery action by an even stronger investigation into the salvage options. It's really a good time to explore all the possibilities to mitigate the loss, and he should not only do it for his own sake or the sake of his client, he should do it with a view to oppose those findings to the ocean carrier. The ocean carrier in COVID times may want to act in a certain way to suit his own interests, discharge quickly a cargo to get another job somewhere. Well, this is perhaps not what is best for this cargo, and cargo recovery agents in COVID times have to be even more proactive in terms of salvage sales. And this is very true because we have seen, and I was involved in a case recently where actually the shortage of cargo in a certain market meant that the cargo became more expensive. So the salvage sale actually became a profit. So this is really worth looking at what you do in terms of salvage as a recovery agent. And that takes us to the next thing, which I've got to say I'm very keen on. This is about keeping some cards close to your chest. When you carry those investigations, you may actually almost find out more than you're looking for. And it may not be wise as a cargo recovery agent to disclose everything you find. And the reason is that by releasing that information, you actually shoot yourself in the foot because you can potentially enable the P&I insurers of the ship owner to walk away from the cover. And you have to be quite subtle about disclosing the right level of information. In times of COVID, this is very important because you want the support of the P&I Club. They are very stable institutions. Ship owners may not be. So really your financial target is that. And you have to be very, very careful that you obtain letters of guarantees and letters of guarantees from proper institutions. So of course, IG P&I clubs or first-class liability insurers. As far as MGAs are concerned, I would be a little bit careful. Of course, they are good insurers, but I would always make sure that the actual insurers sign those documents. So you need to really, as a recovery agent in times of COVID, be very, very, very careful because your targets may disappear. Obviously, you can consider direct actions. That's the same logic. Your primary target can disappear, so you want to be able to drag into the action the insurers behind your target. And as a conclusion for today, I would say that I really believe that yes, COVID is a problem, but at the end of the day, shipping is a sum of problems. And this is, from my point of view, another bump in the journey. And we'll look at this in a few years' time thinking, okay, we managed it. So it's really about being creative, embracing the challenge, working harder probably, and finding ways to decode the problems, avoid the tricks. And that's where cargo recovery agents can bring a lot of value, in my opinion, especially when it comes to arrest. And the previous participant mentioned all the tricks around the arrest orders, and I agree with that. It's not necessarily the best thing to do in times of COVID. It can be, but think twice. So if you have any question, I'm very happy to answer that, either now or maybe by email, as you wish. Thank you very much.
Thank you, Anthony. Thank you very much. Every step becomes more challenging. That sounds like a great motto for every business nowadays, and for this webinar, of course. Thank you very much for your time and for your presentation. And now we will travel virtually to the Asia. And let me welcome here Naya Kontatong from the GTGB International Lawyers from Thailand. Hello, I'm sorry if I misspelled. Nehon?
Hello.
Yes, we hear you.
Hello.
Hello.
Yeah,
yes,
yeah,
we
yeah.
hear you very well and see you, of course.
Okay. From my topic is talk about in Thailand and Asia dispute resolution, and I think this is the topic is quite far from all of you because of I guess that
Oh, something gone wrong? Are you with us? Ah, yeah. Yes, great. Something with internet, of course. Challenge, every step becomes more challenging.
Hello. Yeah.
Yeah, now we see you see your screen.
Yeah. Okay, sure. Okay, I will start on the our topic on the dispute resolution in Thailand and Asia. First, we talk about the Thailand first because of I based it in Thailand and also also my jurisdiction. In Thailand now we have the way of the resolve of the dispute resolution in court. It's quite well known in Thailand. We have many court systems in Thailand. Another channel is on ADR or alternative dispute resolution. For example, in arbitration and also in mediation. For the Thai court, it's quite a different court and different level in Thailand. You might see in the number of court, constitution court, the court of justice, for example, the civil court, criminal court, and most and especially in the shipping or maritime case, we have the court to conduct the case like the shipping and maritime in the we call that the Central Intellectual Property and International Trade Court to do or conduct this case, and we also have the administrative court, military court, but we will focus on the court of justice first. In Thailand, we have the three level of the court of first instance. In case of the party did not agree with the judgment, the party can appeal to the appeal court, and also in case of did not agree with the appeal court, can also appeal to the Supreme Court with the condition. In the Supreme Court of Thailand, we have the condition of appeal. For example, in only case of the court have no any previous precedent related to this issue or this matter, or this issue is related to the public policy. Another channel of the dispute resolution in Thailand is the arbitration. In Thailand now we have two arbitration center is quite well known. First is the Thai Arbitration Institute, we call TAI. TAI is the institute arbitration conduct by the Justice of Department of Justice of Thailand. Is quite closely with the court. For the another center, we so called Thailand Arbitration Center. You can call that THAC. For the Thailand Arbitration Center, is the new arbitration center is would like to which promoted by the government, and it's quite new center or institution of the arbitration. In Thailand, the arbitration is in the past is not popular or well known because of the local Thai or the business entity in Thailand. They did not confident of the arbitration center because of they did not know the process. They did not believe that the person who did not the justice or who did not the judge can be grant the judgment or can be make the fair judgment to the parties. But now, because of Thailand is the one of the business hub in Southeast Asia, and many contractual party on the multinational transaction would like would like to engage or agree in the arbitration cost. Therefore, if Thai entity or Thai person has to go with the arbitration cost by the enforcement. Therefore, for now, it's quite usually or well known only in the international transaction or international agreement between local Thai entity and the multinational company. For the only in the local Thai cases between local Thai and local Thai or local Thai and the local Thai entities is also did not well known for now. We pass to the number of the arbitration in Thailand in 2019 and 2020. If you see the number of cases is quite small number. In 2019, we have only 30 cases arbitration in Thailand, and it quite increased in this year 2020. It's nearly 50 cases. But if compare with another country, it's quite far. The number of arbitration case is quite far from the arbitration in London or arbitration in Hong Kong or in Singapore. However, in the Thai government try to promote that the arbitration in Thailand will be the new hub of arbitration in the future, because of we have everything, we prompt everything including the number of the lawyer, the number of the arbitrators, and especially they try to promote the shipping case or the transportation case to be used the arbitration to resolve the dispute resolution between the parties. In addition, Thailand also is the member of the New York Convention. Therefore, once you get the award, can also enforce in Thailand in any ways. Another channel of the resolve dispute in Thailand is the mediation. However, the mediation in Thailand is quite not well known because of the Thai party no need to settle the case before come to the court. In the past until arbitration first. After that, they come to disputation in the number of the arbitration case is a little amount of a small. Compare with the Singapore, they have also the court arbitration.
It seems that we have lost him.
I think it's maybe on the internet connection.
Please.
Yeah. Okay. We
No, unfortunately, Nahon, we don't hear you.
Therefore, arbitration in Singapore is quite well known. Is it
No.
do you hear me now?
Yes.
Yeah.
We can do nothing with the
Yeah. I try to quick summarize. I will go ahead with the Singapore first, because of Singapore is the hub of the arbitration in Southeast Asia because of the system. And now many cases related to the shipping case. Hello.
Yes. We can hear you.
Okay. Now the many cases in related to the shipping case in Southeast Asia usually use the arbitration in Singapore, mostly the SISC or SCMA, which is quite well known. Now I think Singapore arbitration is larger well known than Hong Kong also, and some cases we also use London arbitration also. Therefore, the number of the cases in Singapore is quite more number of the another country, the Ince. I have some information from the Chinese lawyer and Chinese in arbitrators. the arbitration in China now is not well known because of the enforcement of arbitration in China now. Some cases have the problem on the enforcement. Whether China have the whether China is the member of the New York Convention, but the court of China also interfere or intervene in the case of the enforcement of arbitration. Therefore, it's quite not. I think some cases is not ruled by the international standard also. Therefore, mostly of the China people or China entity normally use the court is the one stop of the dispute resolution. I think it's quite closely with the Thailand. The last country is Hong Kong. I think Hong Kong is like the Singapore. Arbitration is quite well known, and however, due to the problem on the political in Hong Kong now and from the last year, it's quite affect to the Hong Kong arbitration also. Therefore, some cases the party will change the place of arbitration from Hong Kong to London or from Hong Kong to Singapore. This, I think, Hong Kong might be lost some of the number of cases and also lost on the reputation also for now. In conclusion, in Asia now, some country not usually or not quite closely with the arbitration, but for the some case for the some agreement related to the local country and international or multinational company, they also have to use the arbitration cost, which is the good step to come to every case to be the fair judgment. Because of, in our view now, I think the base of the dispute resolution, especially in the shipping cases, should be arbitration rather than in the court, because of the court. Some country we cannot control on the quality, or we cannot control whether the political can interfere to the court or not. Thank you.
Thank you very much. Thank you. Sorry for some technical network problems. We can do nothing with it. Turbulent times. Thank you once again. And if please send us your presentation so we could share it with everybody who is with us now and who was registered for the event.
Yeah, sure. I will send to you later. Yeah.
And now, Nahon, can you please close the share screen?
Yeah. Okay.
Great. And now is the time to move back to Europe. And we have Luis de San Simon, partner of San Simon and Duch from Spain. Luis, hello. Happy to see you here. Are you with us?
Hi, Igor. How are you?
Yeah, great. Thanks. I'm fine.
Well, first of all, I would like to thank you for Interlegal for inviting me to participate in this seminar. And I am trying to share my the PowerPoint presentation, which I think it is now with you, right?
No, not now.
Let me see. Is it now?
No, green button in the bottom of the screen, the bottom of the screen. Share.
That is what I am trying. Let me see. Something is happening here. Well, I can speak, and I am able to share my presentation. I will be sending to you later, okay?
Okay.
Okay, wonderful. The title of my presentation is The Use of Tankers as Floating Storage and Legal Disputes Between the Owner of the Stored Oil Products and the Owners of the Shore-Based Storage as a consequence of the COVID disruption. Well, as we know, the practice of charterers using oil tankers for floating storage is not a new concept. What is different now is the unprecedented increase of the use of tankers as floating storage due to the collapse in oil prices, partially as a result of COVID-19. Spain, with a long coastline, has witnesses collapsing oil refineries and storage facilities capacity, and therefore a high demand for floating storage. The geographical situation of Spain has increased this. We have to take into account that Spain is a platform to serve North Africa from the Far East, from the Middle East, and from the Americas. It seems that at least in this part of the world, where the offer is quite high, much more higher than the demand, it will continue during some period, and this situation will raise many legal issues where owners accept charters' requests to employ their tankers as floating storage. Some of these issues are where to wait, duration of the storage, impact of the condition of the cargo, the usual cargo degradation, the condition of the vessel tanks, the condition of the valves and the pipe work, potential oil spills, ship-to-ship transfer operations, proper insurance, hull fouling, hull cleaning issues, provisions of crew, rate of hire and duration of hire, etc., etc. All these and other issues are to be carefully considered by owners and charters at the time of allocating the risks to avoid legally and potentially expensive consequences. On the other hand, in the other side of the coin, we have also the legal relationship between the owner of the stored oil products and the owners of the shore-based storage. Due to COVID disruption, storage companies in occasions were and are not able to provide the storage capacity ashore and connected services in Spanish ports. In these circumstances, for instance, could the state of the sanitary alarm or similar measures adopted in Spain be considered as force majeure? In practical terms, for instance, will be the charters of a vessel used as a floating storage entitled to invoke a force majeure because it is unable to discharge the vessel? The representative of BIMCO has explained us about the BIMCO force majeure clause. And in Spain, unlike in the UK, we can raise the issue of the force majeure. It is not needed to be in the contract. What is the force majeure in Spain, which more or less is events that could not be foreseen in the ordinary and normal course of life, unusual and extraordinary, completely unpredictable and unavoidable, which adverse consequences cannot be avoided even if there is a prudent and diligent conduct by the parties. Situations arising from COVID could be or not considered as a case of force majeure and shall be analyzed on a case-by-case basis. Spanish courts, I can mention to you, are quite reluctant to accept force majeure allegations and are very strict when applying the force majeure doctrine. But however, in order to end this short talk, in Spain we have another rule which could be sometimes useful in situations arising from COVID, which is the rule rebus sic stantibus rule, which means more or less that clauses of a contract are agreed according to the circumstances at the time of its signature. So if circumstances change substantially, then the clauses should be modified accordingly. This is a way in which Spain can consider the COVID situations. And this is what I have to say in this short presentation. And if there are any question, I will be very, very happy to answer these questions. Thank you very much for your attention.
Thank you very much, Luis, for your great discussion. Thank you. Maybe you have some questions, and so please feel free to write them in a chat room, and we from time to time will open this window and see what's in there. But we are moving forward to Europe, basically to Italy. We have here Alberto Battini, a big friend of Interlegal. Alberto, are you here with us? Alberto? Valerio, I can see you, but I don't see Alberto.
Yes, I'm here.
Yes.
Hello.
Hello, hello.
Hi. Let me turn this way.
Floor is yours.
Yes.
There is a turn of events because he showed up at the very last time.
Okay, so let me. Okay, here we are. Can you hear me?
Yes, great.
Okay, thank you very much. Thank you for inviting me and my colleague Valerio. I see a lot, many old friend faces, and it's always a pleasure to interact with Interlegal and our friends and partners around the world on different subjects involving shipping. So COVID-19 and ship's crew. What are the implications of ship's crew P&I cover in particular, but generally, what are the implications on ship's crew of these pandemics? Now, there are three main areas, of course, to deal with very briefly. One is P&I. What does P&I cover in this situation? What about defense? And what about the management of the pandemics? I won't waste time, given that the slot is only 10-12 minutes, as I understand, so I won't waste time dealing with the management of the pandemics, but we'll try to concentrate more on P&I cover and defense. So in terms of P&I cover, of course, implications regards coming out from the pandemics regards mainly the crew, of course, possibly persons not carried on board, as well as risk of diversion for the ship, and of course risk of quarantine. So what about if a crew member is ill or dies due to a COVID infection? Now, in this case, the liability for infection with COVID-19 is covered. Is normally covered under club rules in the same manner as the club cover other type of crew illness, including evacuation, repatriation expenses, medical care, and hospitalization. If a crew member is infected ashore, or on the way to join the vessel, or on the way home after disembarking the vessel, now, provided that these periods are covered under the employment contract, then the P&I Club will cover. Otherwise, it won't. And this would normally be covered. Now, if a crew member is displaying symptoms of infection, must be tested for the virus. Now, the reasonable cost of testing for the virus would normally be covered by the club in the same manner as the liabilities for other medical care and associated club costs under the club's rules. If crew members' training or medical certificates expire or are about to expire, and there's not possible to effect crew changes, and we'll come to impossibility of crew changes in a minute, then cover is not prejudiced for crew members whose training or medical certificates expires while they are on board. But if they're not on board and they have to join the vessel, then that could be a problem. Now, will this affect the vessel seaworthiness? Now, not really from a cover point of view, but of course, safe manning levels must always be maintained in accordance with flag state requirements. If a person or guest is infected with COVID-19 while performing work on board the vessel, in this case, the club will only cover the cost in relation to the illness and or the death from the virus, where the applicable law imposes a liability on members, or in case of a contract under the terms of the contract, for example, for surveyors, port agents, port authority personnel, or stevedores. Now, risk of diversion, this is obviously a very hot topic. If diversion expenses are covered in case of COVID-19, of a breakout of COVID-19 on board. Now, if the vessel must divert to secure a treatment for an infected crew member on board, then the extra costs of fuels and other costs are set out in the club rules would be covered. Provided they were incurred solely for the purpose of getting medical treatment and not for other reasons or for additional reasons. Now, are diversion expenses covered when there is a suspected case of COVID-19? So not a case which is tested positive, but a suspected case. Now, in this case, cover of the extra cost for fuel and other items set out in the club's rule will depend on specific circumstances of each case. Provided that extra costs were incurred solely for the purpose of getting medical treatment. This will probably be one of the cases that might be dealt with by the club in the omnibus rule on a case-by-case basis. Quarantine. Now, what if the vessel and or the crew are voluntarily quarantined or self-isolated in a situation when there is no COVID-19 virus on board and no quarantine order has been issued? Now, in this case, there is no cover, of course. But what if the vessel is placed under a quarantine order because of the nationality of the crew or due to a previous port of call, but again, the virus is not present on board? There's no positive testing that can certify that. Now, in this case, is then cost incurred in connection with the quarantine order, again, would not be covered by the P&I Club. So there's always a need for the COVID-19 virus being ascertained as present on board. And what if a crew member is not infected, but is quarantined ashore, again, due to local regulations or policies before joining the vessel or after leaving the vessel? Now, if there is no virus on board the vessel and the vessel is under no quarantine order, in this case, the cost and expenses related to the quarantine of the crew before embarkation or after disembarkation are considered operational in nature and again are not covered under the club's rules. So again, the same prerequisite recurrent is that you have a situation where the COVID-19 virus is being tested as existing on board in a particular moment to be covered. Now, what costs and expenses are covered when the virus is present on board and the vessel is under a quarantine order? In this case, the ship owner would be able to recover only net cost and expenses. This is to say those costs and expenses over and above the vessel usual running costs, of course, which would not have been incurred but for the outbreak of the COVID-19 on board. Now, if there is lost time or similar type of economical losses arising out of the delay, then cover is not available for the loss of time, loss of market, or similar indirect or purely economical losses. Now, if the vessel is not under a quarantine order, but the virus is still anyway present on board and becomes necessary to disinfect the vessel, in this case, the cost and expenses incurred to carry out the disinfection would be covered. but again, if the virus is not present on board, then no cover for costs and expenses incurred in disinfecting the vessel. So that would be a loss prevention measure for which the owner would not have a direct access to the P&I Club cover. Now, defense. I'm sorry, first of all, if my presentation overlap with partially with other colleagues' or presentation to some extent. But of course, again, I take the risk to repeat that if other colleagues already covered these, that in terms of defense, of course, claims that may arise are owners' claims, charterers' claims, third parties' claims, or others. In terms of owners' claims, of course, we would expect the usual claim in these cases like breach of warranty or demurrage detention claims, indemnities for claims relating to illness or death of crew, indemnities from charters for losses and claims brought against owners by third parties, indemnities for disinfection expenses and time vessel spends in quarantine, etc. Charterers' claims were typical charter claim with, of course, safe port claims, breach of charter for unsafe port or allegations of unsafe port claims, recover of overpaid hire, and of course half hire during periods of quarantine or detention due to crew or illness, indemnities for claims brought by third parties, late time demurrage exclusions, and force majeure and frustration declarations to suspend or to avoid contractual liabilities and obligations. In terms of third parties claims, well, what we can expect is claims, of course, by receivers for not receiving goods or receiving goods later than expected, damages to cargo resulting out of delay, especially perishable cargo, claims by third parties entirely unconnected with adventure, claiming that charters or owners are responsible for spreading the disease. These are obviously less possible, but possible and in fact frequent in the cruise ship industry. Now the question is here, do I have cover if I fix my vessel knowing that it will be going to a port affected by COVID-19? Now, generally, defense cover for both owners and charters will not be prejudiced if a ship is sent to an area affected by COVID-19, also because in those days, any area in the world is affected by COVID-19. However, both owners and charters should always act as a prudent and insured. This is a general rule, of course, and not recklessly. And should consider on a case-by-case basis whether it is prudent or not to proceed to a certain port with the knowledge that would most likely result in a detention or quarantine order on arrival for the vessel at that port, or any subsequent ports having called that port. Obviously, the foreseeable loss or damage is not covered by insurance. So obviously, this is, of course, a circumstance that will have to be dealt on a case-by-case basis, and owners and charters will have, that's why they will have to act as prudent and insured on a case-by-case basis. I won't spend any time on the management. Of course, there are management issues that concerns part restrictions, on-board preventions, on-board mitigations, compliance with statutory and class requirements, which is a very important issue, actually. Unfortunately, we don't have the time to go through that, but the compliance with the statutory and class requirements is one of the main implications in those days affecting the day-by-day operation of the ship owner arising out of the pandemics and managing the COVID-19 cases on board. So I'll just skip all that and go straight to the final issue that I want to touch upon this time, which is are seafarers key workers? There's been a lot of talking on this issue in the recent months. As you all know, in September 2020, IMO posted a joint statement by the United Nations specialized agencies calling on governments to recognize seafarers as key workers in order to enhance their protection from a legislation point of view in connection with the pandemics. And of course, to take action to eliminate any obstacles to crew changes. We have a huge problem with crew changes. Everybody's, of course, aware of that, and that has a lot of implications. We have a situation where we have approximately 300,000 crew members trapped on board ships, unable to be repatriated, and an equal number unable to board ships. And this situation has been highlighted in the Maritime and other international press since the beginning of this crisis. There is obviously all types of problems arising out of this, including the access to medical facilities, which is obviously the most obvious and direct consequence, but there are also implications on safety of ship management due to fatigue, burnout, situations of crew, and crew burnout is of course one of the main problem at the moment, also for insurers, one of the main concern. No doubt that urgent action needs to be taken to avoid a humanitarian disaster. There are, as of 4th of September 2020, IMO reports crew mental health challenges, and in particular mental health issues related predominantly to the COVID pandemic, isolation from friends and family, fatigue and frustration, lack of motivation, inability to socially distance on board the ship, etc., etc. I've just mentioned the Wakashio, which is an emblematic example of what may happen, and in fact, what probably did happen under investigation, but is one of the most likely possibility due to the fatigue of crew on board for the impossibility of effecting crew changes in a reasonable manner because of the pandemic. This is a very large oil spill off Mauritius coast, in which the Japanese bulk carrier Wakashio was involved. She ran aground on a coral reef on 25th of July 2020 and began to leak fuel oil in the following weeks. The chair of the ITF Seafarer section, that Mr. David Heindel, said that it has been reported that most of the crew on the Wakashio had been kept on board beyond their normal contractual terms. And he added, while it would be premature to speculate on the findings of ongoing investigations, it is appropriate to remember that during the present crew change crisis, we have warned of the threat to human life, property, and the environment from an increasingly tired and fatigued global seafaring workforce. And of course, we have to believe that. What about solutions? Solutions are few and complex, especially in a context of international travel restrictions. The seafarers have a right of repatriation, for example, under the Maritime Labour Convention 2006, but such rights and consequential fines are of limited use, for example, under the 2014 UK regulations, because they're being diluted by the owner's defense of taking all reasonable steps to ensure compliance. And of course, the ship owner has his right and quite correctly says, yes, I'm doing all my best and taking all reasonable steps. What can I do if the port that I'm calling does not allow me to disembark the crew? There's no way I can go around that. So why should I get a sanction? So no offense and therefore no recourse for seafarers. Therefore, MLC 2006 is practically unenforceable. Organizations such as Mission to Seafarers are providing call lines for seafarers and families. The IMO SCIT SCAT, which is the Seafarer Crisis Action Team, is helping to resolve individual cases and so far have resolved a number of very, very urgent cases involving mainly access to medical health care for seriously ill crew, not of COVID, of other type of disease like stroke, heart attacks, or things that could not be disembarked because the nearest port of refuge for them was close to foreign crew disembarkations. IMO endorsed 12-point protocol in a circular letter, which is number 4204, highlighting general measures and procedures designed to ensure crew change can take place safely. Other measures, of course, are remove restrictions on visas, flights, access to COVID testing, and access to medical care and treatment. Finally, from a potential claim viewpoint, of course, owners and their liability insurers should be and are concerned about this developing humanitarian crisis among seafarers. The isolation, the fatigue, the high anxiety levels can develop into recognized psychiatric injury for which seafarers might claim against the ship owner. As we saw before in the Wakashio case, the risk of more fatigue or complacency related accidents is a reality. Of course, the duties occur towards seafarers is a ship owner obligation, which might be breached or might be allegedly breached. And if not properly addressed, recognize these problems can lead to, as we saw, operational problems, but also significant diversion, and significant diversions cost consequently to seek emergency medical assistance, and delays while assistance is obtained or negotiated with ITF potentially involved. I've been as quick as I could, and thank you very much for your attention.
Alberto, thank you very much. You were as quick as you could, but you still have 2 or 3 minutes, so you are right in time. You leave some time for other speakers. Thank you very much.
No problem.
And now it's time to move to France. We have Sebastian Ludgiter here. Sebastian, are you with us?
Hello, Igor. Dobry den, everyone. And big veliki Yakuyu to Interlegal for offering me the opportunity to speak in this panel and to meet some old friends and some interesting speaker, albeit, of course, it is remotely. Let me just try to share my presentations. Okay, I hope that you are now managed to see it. Igor, can you see it?
Yes,
Okay,
yes,
super.
great. Yeah.
Okay, so we could speak, I would say, a day regarding force majeure and COVID, because it is read in so many circumstances, in so many kind of contracts, you know, with the crew, in cruise business, in charter party disputes. Well, here I will just address roughly the issue of force majeure under French law, and also raised and draw the attention of the audience on a particular case which was ruled recently by your court regarding that specific issue. So we go through the notion of force majeure. What are the sources of force majeure? Is a pandemic an event of force majeure? This case I told you about, Total Direct Energy against Électricité de France, and the recommendations that could be raised from that case. So there is 3 criteria for a force majeure. More or less, the situation of French law is the same as Spanish law, which was described by Luis. These 3 criteria are that the event of force majeure in an event which is unforeseeable, unavoidable, and beyond the party's control. These 3 criteria were set up by your court in various decisions among the century. When these 3 criteria are met, consequences are simple. In tort dispute, there is an exoneration from liability of the party who is subject to force majeure event. In a contract, the force majeure is an excuse for non-performance of a contractual obligation. Things have changed, and now these 3 criteria are found in our civil code at Article 12.18, where you have these 3 criteria. And the thing which is important to take in mind, and it is something which was raised by Soren when he made his presentation regarding the BIMCO clause, is that force majeure exists in France irrespective of the clause of the party. It is a legal warranty. As soon as the criteria are met, then the consequence of force majeure should apply, i.e. exoneration of liability. But needless to say, that sometimes it is not easy to describe what is an event beyond the control of the party. Imagine that you have a contract and there is a strike. Is a strike really unforeseeable? Or imagine you have a contract and you have an event from your subcontractor. Is an event from your subcontractor or a fact from your subcontractor really outside the control of the party and could qualify legally as a case of force majeure? For that reason, it is rather common to have in contract clauses which will explain exactly what is a force majeure event and which might extend or diminish, I would say, or restrict the notion of force majeure in comparison with the legal text. For example, here we have a clause, and we're going to speak later on about that clause, which remind what are the 3 criteria of force majeure: external, inevitable, unforeseeable, but we also add another condition, which is that the event makes the execution of the contract impossible in reasonable economic circumstances. Because a thing which is important, and it's another point where French continental law has set up a principle, it has normally a contract should be performed, even if it becomes more expensive to perform it. So now that we have set up the general principle of force majeure, let's see how it applies to pandemic. Could a pandemic could be considered as an event of force majeure? Well, all will depend on the circumstances, all will depend on the facts of the case. For example, if the pandemic existed before the contract was made, the party knew that pandemic existed and could not argue that it was an unforeseeable event. Is there any drugs or medication available? If it is the case, then it is not unavoidable. And also, what is the territorial scope of the pandemic? If we are in such cases, then there is no force majeure event. On the other hand, if the disease is highly contagious, if it spreads everywhere, then it could qualify as a force majeure event. Just to give you two examples, a few years ago, there was a massive, not a massive, but there was a pandemic of a disease called chikungunya. Chikungunya was, created by this mosquito, which is a tiger mosquito. And chikungunya occurred in several French overseas territories. Could it qualify as an event of force majeure? No, replied the court. In particular, because they took into consideration the fact that medicine, drugs were available to cure that disease. On the other hand, there have been some cases regarding not human disease, but I would say animal disease, in particular the disease which affected cows, like the mad cow disease or this kind of disease. Well, in such situations where you have a mad cow disease spreading from one cattle to the other, then the court decided that it was a force majeure event because the disease was spreading so fast that it couldn't prevent, or you couldn't do anything to avoid it. Now, with the COVID-19, things are very different. Things are very different, not only because of the pandemic, but especially because of the measures which were taken worldwide to prevent that pandemic. Most of our countries have been subject to lockdowns, and maybe they will be subject to new lockdowns in the future. For example, in France, from March to May, it was a full lockdown. Nearly everything was closed. Right now, we're in the second lockdown where things are more easier. But the consequences of COVID-19 are far more beyond anything which could have been imagined in respect of former or in respect of previous pandemic which occur in the world. And in that respect, there is a really recent decisions from the Court of Appeal of Paris and the Commercial Court of Paris in a case called Total Direct Energy versus Électricité de France. So to speak briefly, this case does not concern shipping contract, but a contract for the purchase of electricity. In France, traditionally, electricity was supplied and produced by a state-owned company named Électricité de France, EDF. EDF is the only company which manages the nuclear power plant and the coal power plant and the distribution of electricity. A few years ago, some independent electricity operators were allowed to enter that market, including Total Direct Energy. So there is a contract between EDF and Total Direct Energy for the purchase of electricity because once again, only the state-owned company manages a nuclear power plant. The first lockdown occurred in France from March to May. And what's happened, and it is the image that you can see below on the slide, there was a sudden drop in the consumption of electricity. Offices were closed, administration were closed, most of the factories were closed, shops were closed. And of course, the consumption of electricity decreased dramatically in these days. So there was an agreement between the state company, EDF, and the independent company, Total, whereby each year, Total undertook to buy a specific number of quantities of electricity during the whole year at a specific price. And after, Total sell this electricity to its own clients. As I said, because of the COVID outbreak, and especially because of the lockdown, consumption of electricity dropped dramatically. The contract includes a force majeure clause, which is actually the force majeure clause which was mentioned earlier in my presentation. And I read it once again. An event of force majeure is an external, inevitable, and unforeseeable event which make execution of the party's obligation impossible in reasonable economic circumstances. Well, Total raised that clause in order to ask for a suspension of the purchase of electricity. It is really important because contrary to other commodities, you cannot store electricity. You must buy it immediately. The case went in summary proceedings before the President of the Commercial Court of Paris and then before the Court of Appeal of Paris, which rendered a decision last July. What was the result? Well, both jurisdictions, both the first instance and the Court of Appeal, consider that the COVID-19 and the measures which were taken were clearly an external, an inevitable, and a non-foreseeable event. And Total established that continuing to purchase or to buy the electricity based on the term of the contract make it impossible to perform the contract in a reasonable economic way. For that reason, the Court of Appeal of Paris admitted that Total was entitled to request the suspension of the contract. So we have here one clear case where COVID-19 was qualified as a force majeure event. However, there is some limits to that court decision. As mentioned previously, there is two sources regarding the criteria of force majeure. The law, Article 1218 of our Civil Code, but also the clause of the contract. And here, the clause of the contract includes a further conditions, a further element from force majeure, which was the impossibility to perform the contract in a reasonable economic circumstances. And the Court of Appeal raised specifically that point. Then a new question arose. Had this clause not been provided, would the solution reached by our court would have been the same? It is not sure. Second point, which is important, there is an appeal from the decision of the Court of Appeal before a Supreme Court, and we will see what is the decision which will be given probably in 1 year or 2 years. And finally, it is also important to take into consideration the fact that these proceedings were summary proceedings, not proceedings before the judge of the merits. You know, it's only proceedings where the judgeship prima facie. What are the disputes at stake and what are the solutions? So we have these decisions, but we should be cautious with that. And then it raises a new and a last question, is that even if force majeure do not perfectly fit with the COVID-19 pandemic, couldn't we argue that COVID-19 could be a hardship? You know, it is rather common in a contract, apart from the force majeure clause, to have a hardship clause, a clause which provides that when there is a change in the economics regarding the performance of the contract, the party could either suspend the contract or request a renegotiations. For a long time, this hardship was not admissible as a matter of law in France, but it could be admissible if it is provided in a contract. We have been involved in several cases in the 2008 economic crisis where this kind of clause came into actions or where the party wanted this kind of clause to come into action. Things have changed now in our civil code, and there is a specific clause which allows hardship. And the question which will arise is that whether the COVID-19 and the consequences of the pandemic, maybe if they could not qualify as a force majeure, could qualify as a hardship. Well, I thank you, and of course, stay at your disposal if you have any additional questions.
Thank you very much, Sebastian. I believe that COVID, coronavirus, and force majeure are the words of the year, and especially force majeure for the people who are, thanks God, not lawyers, for example, for me. Thank you for your time, and thank you for your presentation.
I just want to quit, let me quit the sharing of screen. Okay.
Yeah. Thank you very much. And now we are moving with the force majeure during COVID times to Andrea Bastlane to Germany with Andrea. Are you with us?
I am with you, and I'm trying to start sharing my. You should see my presentation now, I believe. Right. I'm a bit in the awkward position. Well, thank you first of all for inviting me to speak. Very pleased, very honored. And I'm a bit in the awkward position that we've talked about force majeure quite a bit today already. So quite a few of the things I will talk about today will be things that other speakers have already mentioned. But then again, there's also the saying that you have to hear something at least 3 times so that you can remember it. So I hope there will be something interesting in my presentation after all. Hang on a sec. Right. To start with, German statutory law does not include a definition of force majeure. And accordingly, if you want to rely on force majeure, you do have to include such a clause within your contract. However, and because that is done quite a bit, German case law, and there's quite an extensive bit of that, recognizes the concept of force majeure and describes it as, and that's the definition of our Federal Supreme Court, as an external event caused from the outside by elementary force of nature or by the actions of third parties, which according to human insight or experience was unforeseeable or unpredictable and could not have been avoided or disposed of by commercially acceptable means or with the utmost scrutiny which could realistically have been expected. Now, I believe that's exactly what Sebastian already told us in regard of the French concept, a difference being that, as I understand it, that is codified, whereas here, this is the case law. Also, and that is it is always mentioned, but I believe it's also a part of the unforeseeable or unpredictable event, is that if it is an occurrence that occurs from time and time again, then that would also be excluded from the force majeure. So in a nutshell, we are dealing with an unforeseeable, unavoidable and extraordinary event. And I've not given you or today a certain contract because I believe there's so many different clauses, and depending on the exact wording, the outcome will also differ. However, there's one very important issue. It must influence the duty to perform. So accordingly, if there is a pandemic, for example, COVID-19, but it has no consequence whatsoever on the performance owed under a contract, then of course you cannot rely on a force majeure defense. At what time does the force majeure event have to be unforeseeable? We have heard about that as well already, because obviously if at this stage none of us will be in a position to say, I've never heard of COVID-19 and what is this? So today, maybe if you do have a force majeure clause and you conclude a contract today, that may be to be evaluated differently from older contracts. So what does this mean in regard of the COVID-19 pandemic? As said before, we do have to have a contract which includes a clause, however it is defined, where there is a force majeure clause. And then we have two different types of force majeure clauses, of course, one that does explicitly name an epidemic or a pandemic as an example of force majeure. And in regard of that, the German literature is very clear on that would then also include COVID-19 because it's external, it's an elementary force of nature, or if we're dealing, for example, with an order of the authorities to close a port or not to allow a ship to come, then we have actions of third parties. It was not foreseeable, at least in the past. And you will note that I have included a reference to the dates 8 and 11th March in here. This is not a strict date from which you have to, after which it could not have been unforeseeable anymore, but we have the declaration of the WHO declaring COVID-19 to be a pandemic, a worldwide one. And because we're talking now, or I'm talking about German law, we have the date which the German government considers to be the time as of which parties should have been aware of COVID-19. Now, that was not statutes enacted in regard of shipping, but mostly in regard of consumer contracts, such as the lease. They had a suspension of lease payments, and during which time you could not have been, the contract could not have been terminated. But I believe 8-11 March would then be the date upon which German courts will look at the question of whether or not a contract or a force majeure event was unforeseeable or unpredictable. Obviously, the consequences of COVID-19 changed over the time. And so depending on what COVID-19 event actually affected the performance of the contract, you may still be in a situation where you can say in August, this is something new. This was still unforeseeable, even though there is a pandemic. And also in regard of contracts with, for example, Chinese shipping company, you may find yourself in a position where the courts would say you could have seen already as early as January that there would be problems arising in regard of this disease with Chinese counterparts, and accordingly you should have made a provision in your contract. So again, the contract or the performance has to be affected. I've seen quite a few cases where people and charter parties just because they didn't want to perform, because it wasn't commercially sensible for them any longer, then simply just said, well, COVID-19 and see you, bye-bye, I'm out of this contract. No, that's actually not sufficient. You will have to look at the contractual provisions, and you will have to look at, for example, what is owed under the contract and whether actually that is affected by COVID-19. An example possibly would be if you do have a charter party for a cruise vessel and it just states that you have to provide the vessel, and then you can still provide the vessel, then the other party may not be able to rely on COVID-19 as a force majeure event. they will, and I come to that at a later stage, be able to rely on another provision under German law, but not on the force majeure. On the other hand, for example, if you have, let's say, an inland waterway, a cruise vessel on which you offer not only, and you've chartered this out, and part of your contractual obligation is that you have to provide the vessel, the crew, but also, for example, catering on board of the vessel. Now, during the first lockdown here in Germany, which wasn't as tough as in other parts of Europe, but still restaurants had to close. And now again, since beginning of November, they are closed again in Germany. You would not be able to provide that performance, or because you would not be allowed to cater to people. So there might be a force majeure defense on that. Right. So what is it in case you do have a force majeure clause, but it doesn't mention a pandemic? Well, we've discussed shortly, and I will not repeat it again because we've heard that today quite a few times, that it has to be external, unavoidable, unpredictable, etc. So if there's not an exclusive list of events in the clause in question stating which will be force majeure events under that specific contract, then obviously if you have an unforeseeable, unavoidable, extraordinary event affecting the or some of the performance, then in general a force majeure event will be accepted to exist and will lead to the results as per the contract, be it a suspension of the contract, or be it the cancellation. If we do not have a force majeure clause, and I think I wanted to mention that for the to have a complete picture, then the contract obviously under German law will have to be construed by the general German law provisions, which obviously should read German law provisions. But well, dealing with a pandemic, German may not be that bad. Well, we have two concepts that would then apply. It's one, the concept of impossibility of performance, and one is the interference with the basis of the transaction. And I have provided you here shortly with English translations of these statutory rules so that you get a complete picture. A claim is excluded to the extent that performance is impossible, and then the obligor may refuse the performance. So that is basically the situation you often have. So for example, in the case I just mentioned, you have a cruise vessel and you cannot provide the services you were contractually obliged to provide. Then there is a tendency by the German courts to say, if you can't provide the catering, then obviously you cannot provide the whole concept of that charter party changes, and you cannot perform it, and accordingly neither party is entitled to receive anything under that contract. Whether or not that actually is correct, it's up for discussion, but that's some of the few commercial decisions I've seen so far. Then we have the interference with the basis of the transaction, which is probably, it's very similar to actually to force majeure, but it is a statutory provision, and as such a great way out, because if circumstances which were the basis of a contract significantly change, then if the parties had not foreseen this, you have a right to demand an adaptation, or in certain circumstances also you could then ask for a revocation of the contract. Right. So last but not least, what about those contracts that you did conclude after 7th or 11th March 2020, or which you will conclude afterwards? I already stated that depending on what exactly the contract provides for, you will have a difficulty to rely on a general force majeure clause. You will also, from a German legal point of view, probably have a problem if you just add COVID-19 to your normal force majeure clause, because it would not be unforeseeable or unpredictable. But for the, well, in an uncertain future time, we will all have to deal with this pandemic. And I believe nobody can really say that, for example, problems in regard of a crew change, closures of ports, etc., will be really unforeseeable. German law would then also say if you do have a force majeure clause, and most of the times these are standard clauses, you would or should have a separate clause from now on. May it be saying that COVID-19, in case of COVID-19, closures, etc., will have the following results, because otherwise you would have or have to fear that a court would say, well, you may have included COVID-19, but it was a very surprising inclusion because COVID-19 was no longer unexpected, and thus no real force majeure event. So my suggestion would be that you do look at your charter parties and you do include a separate clause dealing with COVID-19, so in order to still rely on the same results as a basic force majeure clause. And I believe now already my time is up because I started a little bit early, and so that's it. Very rough, very short, very quick run through force majeure in German law. As you will see, or as a summary, you can say we do recognize force majeure clauses in contract. If you don't have them, we do have statutory provisions which will also may help you. And you should have a look at your contracts that you will conclude now, because since the pandemic has been ongoing for almost a year, you will likely not be able to just rely on a force majeure clause any longer, because COVID-19 and its results or implications are no longer really unexpectable, and thus to cover yourself or your contractual partner, you should find specific contractual rules for that. Well, thank you for your attention.
Thank you, Andreas. Thank you once again. Of course, we'll follow your presentation to all attendees and to all speakers. Thank you for your time.
Right, thank you.
Can you please close the sharing?
Yes, I'm doing
Great.
that now.
Right in a minute, we'll move forward to Southeastern Europe, and I will be happy to see Maya Radunovic from Karanovich and Partners. But before this, before speaking about Adriatic Sea, I would like to ask Richard Faint. Richard, are you here with us? Yes, I see you. Richard, will we be able to change your time with George Lambrou? Okay, so after Maya will be your time, and then George Lambrou, because he has another talk right now. Okay, do you mind?
No, I don't.
1 second, 1 second. Okay, great. So Maya, the floor is yours.
Thank you, Igor. I hope you can hear me, right?
Yes, yes, you will. Yes.
Hello, everyone. I'm Maya Radunovic, lawyer from Montenegro, in cooperation with Karanovich and Partners Law Office. It's indeed a pleasure to attend this event. Thank you very much for your invitation, and I sincerely enjoyed the presentations of our colleague. They were really educative. Considering that I come from a region, Southeastern Europe, Adriatic region, which was not so presented, I think, at this conference by now, I would take the opportunity to share some basic information on our region. So let me please share my presentation. Okay, here we are. Well, first let's start with our office. Karanovic and Partners is consisted of a group of 100 and plus lawyers with 25 years history, 11 nationalities. As you can see, there are some impressive numbers here. And yes, we cover more than 6 countries. Maybe this map will help to locate us. So Slovenia, Bosnia and Herzegovina, Montenegro, Albania, North Macedonia, Kosovo, Croatia, and Serbia, of course. You can see that Adriatic coast, which I'm going to talk about today. While our law office handles many commercial cases, but however, we have been developing a maritime practice. Our team you can see on the right side, my colleagues Milena and Alexander, me, myself there. As you can see, we cover most of shipping law areas, which include ship finance, claims, maritime disputes, shipping insurance law, ship arrests, and yachting law. Maybe for your information, there is a list of our typical clients in the area. So going back to maps, geographically and strategically, Adriatic Sea has always been a very important crossroad for international sea lines. What can we see in some newly built initiatives, such as Three Seas Initiative? Adriatic Sea is meant to be more closely connected with the Black Sea as well as Baltic Sea by this fascinating inter-country initiative. Also, so-called 21st century maritime Silk Road also has one very important section in Adriatic coast. I think you can see on this map. Actually, this will be the shortest maritime road from the Asia to Europe, and we expect that Adriatic Sea will certainly take important role over there. But when we go back to Southeastern Europe and some recent trends, probably most of you know that former Yugoslavian Republic broke up in 19th, and that left some strong consequences on the maritime commerce. New maritime policies of former republics are nowadays more oriented towards cruise shipping, privatization of public marinas, and building a modern yacht hubs. Also, Albania has reached increasing popularity on the touristic maps of the world, which also raises up some maritime issues. Seaborne commerce is successfully performed through the biggest ports in our part of Adriatic seas, such as Koper, Rijeka, Zadar, and Bar. Nearshoring of production from China to Eastern Europe also from this region. Rebirth of some of the shipyards, such as shipyard Biela, which is being transformed into a world-class super yacht servicing facility, as well as green shipping, which has been more and more popular in the region, especially with Croatian projects on electric ferries. Here we have briefly just an overview of international legal regimes when it comes to the main international conferences from the maritime law. You can see how our countries actually accepted and ratified most of the conventions. However, going back to the main subject of our meeting here, COVID-19 and shipping. Well, as everywhere or almost everywhere in the world, ports were closed during this year for any passenger transport. They were left only for commercial shipping. That also was followed with withdrawal of seafarers from foreign ships. Countries such as Montenegro and Croatia, are very world famous seafarers countries. So this definitely made an influence on our nationals on the ships worldwide. Also, cruise shipping was actually suffering the hardest restrictions in the area. No disembarkation of ships. Lately, in few months ago, they allowed disembarkation of cruise ships just with cruise, and also lately hot layups were allowed, I think in Montenegro in last month. Before that, no disembarkation of cruise ships at all, unfortunately. When it comes to dispute resolution, well, courts in the region generally remained open. And open for the hearings, court hearings, and also cooperation with the parties. However, online submission of documents was very represented. Actually, still it is, via email or some special online applications. Courts generally accepted one uniform approach that of stay of time bars. Actually, it was not really legally determined by some official governmental acts, but the courts, of course, took that approach that parties will not bear any consequences if they miss the deadlines due to COVID-19, of course. And online hearings, even though there is a legal background for the online hearings, no developed practice yet in our region. Regarding ship arrests, well, actually, we haven't seen any changes or any developments due to COVID-19 when it comes to ship arrests. So they were generally allowed in the region. COVID-19 has not affected the procedure. It still remained urgent procedure. However, we haven't noticed any increase of ship arrests in the region due to insolvency of the ship owners. So for now, I mean, practice will show, but for now it remained pretty much the same. Recent practice in the region of the ship arrests actually relates more to the ship detention, arrests of yachts and the small vessels in the context of smuggling and some criminal activities, but not to the civil claims. Furthermore, when it comes to force majeure clauses, actually, it has still not been raised as a question in the practice. I'm so happy that I heard about force majeure clauses in German, French, and Spanish law. That's why I will not repeat it the same, because our countries follow the civil law tradition, civil law system tradition. So we also don't have definition of force majeure under our laws. Actually, it's quite a descriptive one, unforeseeable, unavoidable, and external event. So considering that it cannot be taken as a granted, force majeure, probably if we take if we have in mind that period before the outbreak of COVID-19 in the world, before the World Health Organization announced the pandemic, maybe in that period we could talk about force majeure as a mean of exemption of liability in COVID as a force majeure event. However, after that, probably knowing our practice of our courts, COVID-19 shall be introduced as a separate clause in the contracts in order to be considered as such. But as I already said, we don't have that kind of practice yet. And really, I'm looking forward to BIMCO clause on force majeure, because then we will definitely follow how it is performed in our region, in the shipping industry. Well, here we have yacht sale and yacht charters, bareboard and skippered, because it's really important source of tourism and shipping sector in the region, in the Adriatic region. So there have been noted contracts cancellation, of course, especially in yacht sale and purchase, frustration of contracts also, as well as delays in yacht delivery. Most of ports and marinas in the region undertook that leniency policy on tax payments of marina charges, which was some kind of small contribution to this overall situation. Well, that was my brief presentation. As you could see, I had intention to just introduce you with our region, with our scope of work. I will be at your disposal for any questions you have. And once more, thank you for your invitation.
Maya, thank you very much for your short overview of what's going on in Southeastern Europe and Adriatic Sea. Thank you for your time. Please send us after the end your presentation so we could share it.
Of course. I'm trying to stop sharing. Sorry. Okay, I'm fine, I think now.
Yeah, great.
Thank you.
Now, George, do you have time now? Because you asked us to change time. So if you are ready, you can start now. If you are not ready, Richard Faintville can change the time with you.
I wouldn't mind switching with Richard, if that's all right.
Okay. So Richard, that's 1 second. Richard, can you turn on your microphone? It's at the bottom. Yes, now.
Yeah.
Yeah, great.
Can you hear me now?
Yes, we can hear you and see you well. Okay, so George, you'll be after Richard.
Okay, well, thank you very much. I've missed my trips to Ukraine, but I'm glad that you've included me in on this seminar. It's very interesting. I have some slides. I have a paper, of course, but I don't want to repeat what others have said before me, so I'll go as quickly as I can, and if I'm skipping things, then please pick them up on the paper. Okay, I started the introduction by saying we're all aware of the impact of COVID-19, so I won't say any more on that. Shipping seafarers are the lifeblood of world trade. Again, that's been mentioned. I would add that I have already written some articles on COVID-19 for Ship Arrested, and if you are reading Ship Arrested news, then you might see something of what I've already said on it. My approach will be a little different from some of the others. History tells us that, well, it's said if you ignore history, it will repeat itself. And in my paper, I put a short note. There are three major pandemics that have been through the world before. In 541, it was called the Justinian plague, started in Africa, spread to the Mediterranean. In 542, its peak was in Constantinople, now Istanbul, of course. The records say 5,000 plus deaths a day. Some go as high as 10,000. We then moved to 1347 to 1351, the European Black Death. Like COVID-19, it's said to started in Asia. It doesn't say China, but Asia, spread to Crimea, into Europe, and then Russia. In 1346, European ports knew of a plague epidemic in the east. The plague came via the Crimea. The Tatar armies of Khan Janiberg They were holding siege to a town called Kaffa, which I believe is now Fedosa in Ukraine, but they didn't succeed. They left a certain memento by catapulting dead, deceased bodies into the town. Anyway, the plague continued throughout the world in small epidemics. In 1665, we had the Great Plague of London. My pages have just got stuck, bear with me. 1894, we have another pandemic, the last one. Like COVID-19, it originated in China, Yunnan, spread to Hong Kong, India, and the rest of the world by 1900. The plague has never really gone away. I put this in a footnote. You can read it, please, in my paper. The plague waxed and waned over the next 50 years, and by 1959 had caused over 15 million deaths. Epidemics come and go, but 3 world pandemics have had a huge impact on society, socially, economically, and culturally. And what we are seeing now is another change in society. History repeats itself. So the aim of this paper, we must all learn to live with the consequences. The welcome rollout of vaccines is a key development, but it's not an instant cure. Parties active in our field would do well to review their current practices, how they trade, to ensure that they have been seen to have planned as far as possible to be able to avoid the risk of inevitable delays that occur when you're caught up in a pandemic event. Port health control of infectious diseases. Any vessel entering harbour has to deal with port health, request free fatigue. No problems, you get your free fatigue, which is a license to go about your business. If there is a health problem, then you don't get free fatigue and you go to quarantine. Quarantine was developed in the Adriatic. I've put a little note in. 1374, Venice, then a very important trading state, developed the idea of quarantine, stopping people from landing cargo, going ashore. Victims were isolated in hospitals. In 1387, the Republic of Ragusa, now Dubrovnik, created a landing station away from the city and harbour for travellers and seamen. They were held for 30 days. This was considered too short. Excuse me. And in 1403, Venice introduced a quarantine period of 40 days, quarantena, and it's from there that we get the word quarantine. Okay. Possible areas of dispute arising from a COVID-19 event, force majeure. I'm not going to repeat what's been said by Sebastian and Andrea. But just quickly, English law has no concept of force majeure. If your contract has a FM clause, then an arbitration tribunal or court will apply that clause, but they will apply it very strictly. As has been said, a party claiming FM is trying to excuse himself from ongoing performance. Many sale of goods contracts, charter parties and bills of lading, contain FM clauses. The intention is to modify the performance of the contract, okay? A typical commodity FM clause will effectively stop the clock for a period of up to 60 days. If you can get away from the event, if the fire has burned down your loading arm and can be repaired, you can pick up again and continue with performance, okay? A party, as has been said, a party claiming FM would need to show what the event is, whether it's covered within the text of the force majeure clause in the contract. You would have to show inability to perform. If there are contractual notices for FM, these have to be performed. If you don't perform, it may be fatal to your claim. I'm quite interested, Sebastian, in your total case. I'd be very interested to follow what the Supreme Court finally comes with. Andrea, you spoke of suggested a special clause in a charter party. I'm going to propose a rider to charter parties, which would help to communicate between the parties and to show what those parties have done in the performance of their contract. Okay, so I'm skipping through my notes because it's been covered perhaps better than me. One point I will add, China Council for Promotion of International Trade has been issuing FM certificates upon request to Chinese companies in contracts with foreign companies. If you look on the web, a number of law firms and legal advisors have urged caution for their clients who deal with these FM clauses. I would go along with that. Speak to your lawyers. We've also gone over the question of reasonable efforts to avoid force majeure. Again, what I'm suggesting is for parties to review their current practices. This is a result of pandemics. Historically, things have changed. Venice introduced port health after the pandemic. We are going to have to change our practices as well. If it's not force majeure, then it could be frustration. Okay, English law does recognize frustration, an event which renders the contract either impossible to perform or makes its performance radically different through no fault of either party, can automatically terminate a contract. Frustration usually requires serious and significant events to occur that undermine the entire purpose of the contract. Not that easy. I put in a footnote for quite a famous case, and I hope I get the pronunciation right, Sakuragu v. Nobly Thor. It's a cargo of Sudanese groundnuts sold sift towards Hamburg. The usual route being Suez was not possible, it was closed. They had to go around the Cape. The seller opted not to perform. The court, and it went to the House of Lords, held that even though performance was longer and more expensive, the seller had to perform. So even for a contract to be frustrated and killed off, there has to be no other possible means of performance. If a port is unsafe, owners may be right to refuse to call there. So with regard to testing the risk of unsafety, a party needs to demonstrate that care has been taken to show that protective measures were in place. This is to argue that the intended port may still be considered safe despite COVID-19. And I've attached a draft rider, which we'll come to later. FM, it's agreed, FM is a difficult point. It emphasizes the need to have a pre-shipment protocol in place. It would require shippers and owners to work together. This idea of cooperation is the central theme of my paper. Okay, where a port has become unsafe, the general rule is charterers have an obligation to nominate another alternative port. However, if the ship was in port and has been granted free fatigue, then it's likely the charterers will be held liable for the cost of deviation to that alternative. COVID-19 will in principle give owners a right to refuse to call. The rights, obligations, liabilities, I'm not going to go into that. It's not the subject for discussion today. But there could be questions of who is liable for COVID-19 delays. Check with your lawyers. Owners may be concerned that proceeding to such a port could expose the crew to COVID-19, endanger their health. The crew themselves may also raise concerns. I've heard a story of a crew refusing to allow stevedores to board a ship. Is a COVID port an unsafe port? You've heard a lot of that today. It will be on a case-by-case basis. I would suggest that traders, charterers contact their lawyers quickly. I also suggest have a look at the web and the various offerings from the different P&I clubs. This will encourage you to speak to your lawyers very quickly. Any such dispute will turn on its facts, and the facts are the spread of the virus in the port, country in question, and the measures put in place to limit contact between the crew and shore personnel. My view, it may be difficult to establish that a port is unsafe within the legal definition of unsafety. Again, the emphasis will be on the precautions taken. Owners refusing to proceed to a nominated port could well be making a risky choice and expose themselves to substantial claims from charterers for delays, losses. As you can imagine, and I've spent a lot of my past 30 odd years mainly on the commodity trades, suppliers, shippers, warehouses, silos would not be happy if the ship doesn't arrive or cannot get in. The BIMCO infectious or contagious disease clause. Soren has gone over this, so I'll just make some quick comments. It was released in response to the Ebola outbreak, yes, the virus outbreak. That did not become a pandemic, it remained an epidemic. If in your supply chain between two countries, one party has used the above clause in their charter party, it probably does give owners additional rights. In essence, the clause gives owners the right to leave or refuse to proceed to a port where there is a risk of exposure. And I think the words are to a highly infectious or contagious disease that is seriously harmful to humans, or to a risk of quarantine or restrictions. Charterers are required to provide alternative voyages and indemnify owners for additional costs or expenses incurred as a result of complying with such orders. It makes it expressly clear that the ship will remain on hire throughout. Soren suggested that the take-up from charterers was fairly limited, probably because they consider this clause to be a little bit draconian and favouring owners. A trading company who will remain nameless asked me to comment on an owner who also will remain nameless proposed COVID clause put to them. I'm not going to spend time on this. It's available in the paper. But the points I've raised, delays was not defined. The charterers would be liable for all time lost. We all know how easy it is to argue over time lost. The crunch really was a clause that read costs incurred relating to the vessel's obstruction to operate at both ends arising out of or in connection with any disease, but without limitation to COVID-19, such as but not limited to screening, cleaning, blah, blah, blah. Related to the vessel's obstruction to operate at both ends. What is meant by obstruction? Is there an alternative performance available? Both parties would benefit if this was clearly spelt out. Again, I come back, the wording that the owner would indemnify the charterers is probably the reason why this is not being picked up. Okay, I'm going to go now to my slide. As an alternative to BIMCO and other clauses, I'll quickly go through my suggested writer clause, which is shown at the end of the paper. Slide 1, well, it's just to make it clear, if we can go to slide 2, please, or can I do that? Let me see.
already. I've already.
Oh, okay. This is the whole point of my presentation. A rider clause to clarify charterers and owners' obligations in the event that a chartered ship encounters problems from COVID-19 or any other disease. Clarity of communication. If we can go to the next one, please. Definitions. For the couple of owners' clauses that I've seen, there has been no definition of what the disease is. And I put it down here. I borrowed this from BIMCO, but I've expanded it to include as established by the WHO, the World Health Authority. Affected area, again, I've borrowed this from BIMCO, but expanded it where so that the affected area is defined by the World Health Organization or the local state. And they've imposed a lockdown because of that. Delays, fairly simple, any delay that interrupts the performance of the vessel under the contract. Can we go to the next one, please? Costs. Again, I found the BIMCO clause a little bit difficult. I spelt it out here. We have already had Alberto mentioning medical costs. I've hopefully expanded it to try and clarify what is going on. All time lost and cost incurred by reason of such delay must be fully itemized and supported by valid documentation. This, I've seen problems in my maritime arbitration seat. Warranties. Owners warrant that prior to deliver, they have had a valid testing policy in place for any and every crew member on board, and or a valid testing policy for any person authorized to board the vessel in any capacity, whether that's cargo recovery, a surveyor, or somebody from missions to seamen. And that the owners are compliant fully with the ship and port security facility and will maintain a log for that. And they also to ensure any management company employed by them fully licensed, such information to be made available to charterers on demand. To manage a COVID problem, we need to know who is going on board, and we need that to be recorded. Okay, all requirements of the IMSBC code to be followed as normal. Here we're going on to what I'm suggesting, a pre-arrival system put in place between the shipper, the seller, the shipper, or the terminal, to be carried out in advance of the ship's arrival by email, to be risk assessed and agreed by terminal berth operators and the ship's responsible officer, information to be exchanged to cover, and I've listed that out, I won't go through it. A lot of this is normal practice, the exchange of grain calculations, etc. I'm trying to put this all into one place, in one clause. Can we go to the next one, please? A ship shore safety checklist. Again, this comes from an IMO code. It would benefit not only in establishing the precautions for COVID-19, but in any other dispute that's going to arise, an unsafe berth, the time lost, anything. This pre-advice checklist would be a benefit to arbitrators having to sort out problems on a number of issues. Next slide, please. I think we mixed them up a little bit. I've already gone over this. The shipshore document exchange, it's in place already. I've added a clause that all the crew are trained in COVID-19 precautions, and equally shore operators would need to show that their terminal staff, stevedores, have all been trained and are following proper precautions, wearing PPE, etc., etc. Okay, can we go to the next one, please? Right, before we start with the loading of the cargo or discharge of the cargo, a discussion on board in an agreed meeting place between shore staff and the ship. The ship would have to set up an office, a deck office, whatever, to confirm what has been discussed in the pre-arrival email exchanges, to confirm COVID-19 precautions, check on any outstanding items, check gangway, mooring, review local conditions, cargo hold, cargo tank entry procedures, arrangements for suspension of loading and unloading. These are all normal practice, but again, I think it would be better if these are all in one place, in one rider. Okay. What I'm aiming here is to ensure good cooperation and communication, to ensure safe management of the risk presented by COVID-19 at the ship-shore interface. Any non-compliance by crew members with the required protocols seen by the shore terminal would be immediately reported to the master. In the event that the issue is not quickly resolved, the master issues a notice of protest, load and discharge stop. Any time lost while we sort this out, not to count. If it goes on, then obviously time will count. Any non-compliance by the shore personnel observed by the duty officer on cargo watch will entitle the master to take a similar action. He can issue a letter of protest, and time will continue to count if the ship is not at fault. I've also put in as the last point, the terminal operator to keep a log of personnel who board the ship. It's an obligation on the ship. Why not on the shore operator to do the same? This could be important if there is a COVID-19 victim. It would allow contact tracing to be made available on information on contact tracing to be made available on demand. So the continuation of a contracted voyage when and if the ship confronts a problem arising from a disease or having to deal with the effect of an affected area. Again, I'm bringing in the official notice from the World Health Authority or the local authority imposing the lockdown, and owners, disponent owners immediately notified charterers. Charterers and owners shall agree within 48 hours. And this is perhaps the crux of my offer suggestion. Within 48 hours, they decide whether the ship shall proceed to a contractually agreed place or port, or continue to remain at the place when that she was when the official notice was published. Only on agreement between the parties shall the ship proceed to another port, and charterers shall issue alternative voyage orders on terms agreed between the parties by way of an addendum to the underlying fixture. One of the things which strikes me so far from what I've heard is we are not seeing many cases reaching arbitration or the courts on this. I think this is possibly because, speaking to my trading friends, the amount of money involved and waiting for the result of arbitration doesn't alter the problem. The ship in the port will be stopped. Loading, discharging will be stopped. I think the traders, ship owners are coming to arrangements outside of any arbitration clause or dispute resolution clause and just getting on with it. But if they can't, my suggestion here is that if there's no agreement within 48 hours, both sides state their objection in writing by putting forward their proposals. That has to be supported. Next slide, please. If they can't reach an agreement, then appoint an arbitrator without delay, the chairman being appointed by the president of the LMAA. Perhaps it could be somebody else. The aim of such reference to arbitration shall be to obtain a speedy decision within 5 working days of each party having served their written objection. This puts pressure on the arbitrator. such an arbitration to be a separate procedural approach to the main arbitration clause, still to be governed by English law, which probably governs the Charter Party and its jurisdiction in the seat in London. Parties agreed to abide by the decision of the arbitration tribunal, subject to the right of any appeal to the High Court. Not that difficult to appeal arbitration decisions in the English system at the moment. That's another subject. Time not to count during any such arbitration procedure. Crew changes. Julian brought this up as the first speaker. I've taken the view that crew changes are principally the responsibility of owners, and therefore this risk falls on owners. Alberto has given some figures and somebody else gave some figures. I checked with the ILO, and at the end of October, they say that there are 1.6 million seafarers in this world. They say that 400,000 are now covered by or affected by problems of COVID-19. That is huge. These are people who have extended their contracts or had their contracts extended compulsory. They simply can't go home and they can't afford to fly home. I can quote one example from my own, not in any way connected to COVID-19, but to give you some impression of what it feels like. Many years ago, when I was a young sailor, we had a change of orders and ended up in somewhere in the south of France over Christmas. Because of Christmas, because of the change of orders, we didn't get the usual mail. This is before mobile phones and email. The captain produced a Christmas card. One Christmas card presented by the lady who had christened the vessel, the ship's mother. That was our crew Christmas card for the year. We felt miserable. You can imagine how the crew feel on people who have been there for over 11 months. I agree, ship's crew should be considered to be frontline workers, and the more that we do this, the better. Julian, I have a suggestion for you and your ideas to support the crew. There's another song which you could look at, written in 1656. I'll give you the front line. Ye gentlemen of England that live at home at ease, how little do you think of the perils of the seas? I think that would be good if you're going out to drum up support for crew. Okay.
George, thank you very much. Thank you.
Just a quick conclusion.
Okay.
Right, history, because I've referred to the three earlier pandemics. History tells us this will not go away. The plague is still with us. Just 2 diseases have been eradicated, smallpox and rinderpest. World Health is working on removing diseases. Removing viruses, I think, will be more difficult. COVID-19 is a commercial risk. And when I say risk, I use the English shorthand to mean who is going to pay. COVID-19 will require a change in procedure. We need to have better protocols that require good cooperation. We need better communication and understanding. A final word to all parties, non-legal parties: take legal advice. Charter parties generally incorporate Hague-Bisbee rules. They do have the restrictions, which have already been mentioned, arising from quarantine restrictions. Time charters the same. COVID-19 has slowed down the entrance to arbitration and the courts. Daniella has spoken of the need to have more virtual conferences. I totally agree with that. Precaution, again, from my own experience, of an appeal, I was sitting as on the tribunal in London. We identified who the witness was. We asked him to confirm that he was on his own, that he didn't have any legal advice standing next to him. He said yes. We asked him to pick up a file. He couldn't find it. The file was provided by an arm coming onto screen and putting the file in front of him. Yes, we are all going to have to work with virtual meetings, but we do need to have caution. I hope I haven't taken up too much time, and I hope I've given some ideas. Thank you very much, and thanks again to Interlegal. I look forward to my next trip to Odessa.
We hope so, and we are looking forward to see you again in Odessa too. Thank you, George. Thank you, Richard. And now, as you remember, we have a sort of arbitration panel, and the next one, our speaker will be George Landru, independent arbitrator of ICC, LMAA, LCA, and other arbitrations, and also a partner at Keystone Law. George, hello.
Hello. Thank you very much. And I just wanted to say really how happy I am to see so many friends and colleagues here. We are all, working in our isolated places and seeing so many familiar faces and good friends over the years is really wonderful. So thank you. And I really also wanted to send a special thanks to Interlegal, who have been really at the forefront, I think, from as far as I can remember, of providing the vehicle for friends and colleagues to get together, exchange ideas, on top of being a first-rate law firm in the region and around the world. And it's been a pleasure to see Interlegal grow and expand over the years. I congratulate you on your anniversary. And not just in maritime law, but in many other areas where I see that Interlegal is really excelling, and a real congratulations for your anniversary. It's wonderful to see that. My subject today is about the small claims procedure under the LMAA. Now, should I share my screen, or will you put the slides up?
Yes. Please share your screen. We don't have your presentation. So
okay. Okay, so I'm not going to talk about COVID. So this is going to talk about a little bit about some of the small interesting issues which I've come across both as an arbitrator and as a lawyer in these cases. We're all familiar with the small claims procedure, which we see so often in charter parties or in bills of lading. And I just wanted to share in the next 10 minutes or so some of what I call potential traps of the small claims procedure. Some things to watch out for. It's a wonderful procedure. It's been served the parties extremely well. But there are just a few things for certain types of cases it might not be appropriate. And you might run into some difficulties. And I just wanted to spend a few minutes on that. So the first potential trap of the small claims procedure is, when does it apply? So it does not apply simply by default. If we talk about arbitration clauses, arbitration in London under English law does not mean the small claims procedure applies. If we talk about arbitration conducted under the LMA terms, also small claims procedure does not apply unless the parties agree that it applies afterwards. It will apply if there's mention of the small claims procedure, and it may also apply if there's a reference to LMA terms and procedures, and the words and procedures may incorporate then therefore the small claims. But it doesn't also, just because you have a dispute which is 50,000 or less, doesn't necessarily mean that the small claims procedure is automatically going to apply. Potential trap number 2. It is meant to be cheap and cheerful expedited procedure. But that means you need to work pretty hard. You've got to get the time frames are tight, they're fixed, and the arbitrator is going to move things along quite quickly. Short written submissions, claim submissions, 2,500 words. That's about 5 pages. And you're limited to that 5 pages. Any reply submissions might be 1,000 words limit. So you're talking about extremely short submissions. Disclosure of documents are not going to be available as a matter of course unless they're ordered. No expert reports. Certainly no oral hearing unless the tribunal requires it. So this is if you've got a very complicated or expert or technical dispute, then are you going to have the tools available? You might not automatically have them available to you. The tribunal might, if you put in 10 pages or 15 pages of submissions, the tribunal might reject them and say, sorry, it's 2,500 words. You've got to comply with that. Try again. And then you're going to have all this difficulty of trying to go through and reduce your claim submissions to fit the 2,500 word limit. So non-compliance can be considered inconsistent with the spirit of the rules, and you may be penalized in costs for that. Time extensions, less likely to be granted in an expedited procedure, and certainly any request for a time extension is going to have to be made before that time extension expires. Potential tap number 3, consolidated or concurrent. Now, consolidated means you've got 4 different arbitrations, you put them all together, you come up with one award. Concurrent is you're still going to have 5 awards, but they're all held, the decision or the hearing are all conducted at the same time. Okay, so imagine a scenario in some shipping disputes where you might have 15 bills of lading in relation to the same cargo on the same vessel. Now, that technically speaking is going to be 15 different arbitration clauses, 15 different contracts, 15 different bills of lading. The value of the cargo claim or the damage might be 500,000. But if you're splitting that up into 15 different bills of lading, then each one might require the application of the small claims procedure. So what's going to happen in that scenario? Well, unless the parties agree to confer such power to the tribunal, the tribunal has no power to consolidate those proceedings or order concurrent hearings under the small claims procedure, under the Act. So that means that you're going to be stuck with 15 different arbitrations, and the arbitrator can do very little about that. And unlike under the standard LMA terms, the small claims procedure does not allow the arbitrator to conduct the references even concurrently. Certainly no consolidation is allowed, but even concurrent hearings, unless the parties agree. So what does that mean? Well, if you think about the costs of the arbitration, it might mean, remember in the small claims procedure, you've got to pay up front the arbitrator. So if you have 15 arbitrations, all of the small claims procedure, you're going to have to pay £4,000 up front in the claimant for each one. You may be looking at a case where you're going to have to pay £60,000 up front, plus any administration fees on one shipment of damaged cargo. And that might work for or against you depending on whether you're the claimant or the respondent, but it may also have it surprisingly it might be a surprise to you if you're in that situation. The arbitrator will have no power to consolidate or conduct those concurrently. And that also means that you might then lose one of the benefits of the small claims procedure, which is the low cost. Potential trap number 4, limits on recoverable costs. In my experience, the small claims which go to arbitration are actually extremely complicated. Otherwise, they would have settled. Sometimes large claims are very simple. And they go to arbitration because even if you can knock 5 or 10% off of the large claim, it's still going to be worth it. The small claim can be a real hard nut to crack. Each side believes they're right. There may be some uncertainty in the law. They might be incredibly complex. And the costs of the lawyers who are going to have to work on this might be far in excess of the amount which you're going to recover in the arbitration. Now, which is about £5,000 for a claim. Fortunately, the arbitrator does have the power under small claims procedure to apply the normal LMA terms if that the matter is extremely complex, but that's certainly up to the discretion of the arbitrator unless the parties agree. And 5, potentially the last one, is that there is no right to appeal. Now, once you have the award, that's final. Now, there's no right to appeal on the point of law. So even if the arbitrator gets it wrong on a point of law, that's what you're stuck with. And just to clarify, however, that does not mean that you cannot appeal under the arbitrator's substantive jurisdiction. So if you suddenly you didn't know about this arbitration and you found out about it at the very end, you would might have an ability to appeal on procedural or jurisdictional matters. But the party can apply to the tribunal for correction of any accidental mistake or omission. That doesn't mean you can apply to the tribunal to change their decision, but you can apply to the tribunal for small mistakes. So those are the 5 traps to be aware of. I call them traps. It depends on the particular case that you're in. It may be usually 9 times out of 10, the small claims procedure is brilliant, but there may be some circumstances where you might find yourself in a procedure which isn't really quite suitable for the case. And that's when you're going to want to take some decision on how you're going to proceed to avoid that. So thank you very much.
George, thank you very much. Thank you for your time, for your presentation. Please send it to us so we could follow up it to all participants.
Of course.
Please close your share screen.
Of course.
And as you remember, is a time of arbitrators, and I'm happy to see here Ivana Darichenko, who is GAFTA Force Arbitrator, International Trade and Dispute Resolution Expert and Advisor. Ivana, are you here with us?
Yes, I am indeed.
Yes. George, can you please?
I'm trying. Hold on 1 second.
Okay, I'll do it for you.
Okay, great. Thank you.
Ivana, the floor is yours.
Yeah, now let me try and share my screen. That is always the greatest challenge.
Great.
As it seems, well, wait, it's not yet great. It's not working yet. Yay. Now it is working. Good. So very good afternoon, everyone. Thank you very much, Iga, for the introduction, and thanks very much for Interlegal for having me. It's always a pleasure to share a panel with so many distinguished and reputable and experienced professionals. So I feel like very privileged already. It's wonderful to see so many good faces, and I do remember times when we were all meeting at similar functions in Odessa, in Kiev, and all over the world. Hopefully that will come back soon, and we will soon rejoice in some kind of normal working scenario. There've been a lot of talk already about COVID, what is it, force majeure, not force majeure, so I'm not going to bore you that much. I would just like to take the focus a little bit from shipping to trade, since that's basically more of my bread and butter, and hopefully share a couple of things, share a couple of thoughts, and see where we get at the end of my presentation. So I initially want to talk about 3 things, to divide my presentation into 3 parts. Firstly, we'll talk generally about GAFTA for the benefit of GAFTA arbitration, for the benefit of those who are not perhaps that familiar with the forum. Secondly, I will touch upon some GAFTA statistics, which may be particularly interesting for anyone who's working with the Black Sea. And Ukraine, Russia, as we all know, that's kind of a very interesting and prospective region for grain trade and such. And finally, I will talk about some developments in the procedural rules and generally some other developments in GAFTA processes, which were there as a response to what was happening in the world, in particular to COVID. Finally, if we have time, and I'm sure, well, something tells me that I'm not going to have that much time, but if we do, there's going to be like a quick bonus track of a quick discussion of what COVID-19 generally means for the purposes of GAFTA contracts and what I basically think about it. That is if we have time. So without further ado, We all probably know this. I don't need to go through this in any detail. GAFTA Arbitration is the arbitration service of the Grain and Feed Trade Association, which is the leading grain trading association in the world, which comprises most of the trading members who trade grains and similar commodities. The GAFTA Arbitration Service does a lot of good work generally for traders. It's well recognized in business, and actually privileged to be part of it. The way, the basis for the GAFTA arbitration to work is basically GAFTA contracts itself, because all GAFTA contracts make it very clear that English law applies and GAFTA arbitration rules apply. So whenever you have a grain trading contract which incorporates GAFTA rules, then you will end up with GAFTA arbitration in London. You have choices for small procedure rules, small procedure claims, etc. But the usual de facto position is that you will end up with GAFTA rules 125, which is the standard procedure rule. The GAFTA is one of those rare trade associations, similar to FOSFA, that operates two-tier system. First tier, that's where the majority of the cases turns up. You don't really need to bother with how it started and what is there. You can always just check the slides and check the rules. It's all very straightforward. Mostly all the parties' submissions are being sent through and discussed on the basis of the documents. Everything is reasonably straightforward. On very rare occasions, you may have some oral hearings, but usually it's all very straightforward. However, if the parties are not happy with what happens during the first instance, they can appeal to the GAFTA Board of Appeal. And that would be a totally new rehearing of the dispute. There are certain rules which operate, rules that exist in terms of how all of this should operate. And again, the difference between the first instance and the appeal stage is usually the oral hearing. And this is important because there's been a lot of developments and talk about how oral hearings should work in the post-COVID reality. For the benefit of those lawyers in the presence, lawyers are not allowed to represent the parties even during the hearings. So it's all about trade representatives who are chosen from either the list of arbitrators approved by GAFTA, or who could be your own trading members or your legal counsels, or whoever you feel should represent you at the proceedings. So all very straightforward. The rules haven't changed much. There's some aspects were affected. And before we move there, I would like to quickly touch upon some statistics. That's my my personal interest, because again, as a former Ukrainian, not a former Ukrainian, as a Ukrainian and a former Ukrainian lawyer, I did grow up in the region, and I started among the first people doing a GAFTA work in the region. So it's good to see that even though the years change and the GAFTA membership also increases, the Ukrainian, Russian, and generally Black Sea commodities not only become very popular in the world, as in the Black Sea now became one of the very reliable origins and very popular origins for international trade as such, but unfortunately for the traders and fortunately for us, the Black Sea commodities still remain pretty much on the top of the origins among GAFTA disputes. That probably, again, my view is that the members of the trade in our Black Sea region basically recognize the forum as such and have trust in it, which is probably something we should all be proud of, because we've been helping the region grow and understand GAFTA rules for the past 15 years at least. The most common contracts, again, if you look at the statistics of the past 3 seasons, and again, this is something I've been closely watching every year, you can see that the Black Sea contracts, such as GAFTA 49, which is the FOB ex Black Sea, and GAFTA 48, which is CIF ex Black Sea, Central Eastern Europe, you can see that they're again on the top of the arbitrated contracts. Again, similar to the point which I made before, that is something which the region is now showing. The region believes in the system, the region goes to the system, and that's why I think from now on, For 3 seasons in a row, the regional contracts were in top 5. So I think this tendency is likely to remain for the future. And if we speak generally about GAFTA statistics, again, for the purposes of the benefit of those members of other institutions, lawyers who do not really know how the system works, the rough number of cases per year is between 300 to 400, which if we talk about the first instance cases. In this year, for example, last season, GAFTA issued something like 100+ awards. So not all the claims and not all the cases which are being raised ultimately end up in awards. Sometimes this may be just claims for arbitration, which later get settled. Out of those 100+ awards, about 30%, 25 to 30% of those awards get appealed and go to the second stage. And we're not going to talk about the third right of appeal to the High Court, because that was probably a bit too much. And as some of the representatives, some of the colleagues said, that may be a totally different story for the whole day. So once again, out of those appeal cases, we have about 25 to 30% of GAFTA awards being appealed to the second tier. Out of the second tiers, only about 25 to 30% again get an oral hearing. So on balance, you would probably say that oral hearings are not that important in this business. But if you have a case, and if your case is heavily dependent on witness evidence, or you really think that the arbitrators in the first tier didn't hear you, or you believe that you do need some oral argument, etc., etc., that is where this COVID-19 situation and the after COVID-19 world may become a little bit difficult for you for a number of reasons. Oops. Okay, that was too fast. Let me do it again. 1 second. Yes, here we are. And since I've already started talking about oral hearings, again, even though it doesn't seem like a major part of cases, but it's still a very important arrangement for many parties in the biz. And as we all know, and Daniella mentioned exactly the same thing for LMAA and for other major arbitral institutions, we all are slowly moving to digital. And say, personally, myself, I'm not a big fan of digital oral or virtual oral hearings, because I do believe in the power of argument, and I was trained as a barrister in this country, and I'm learned to speak to someone, not to my screen. But unfortunately, this is now the new normal, and whether we like it or not, we have to learn how to deal with it. The difficulty is that the virtual hearings bring their challenges. Yes, they're more convenient in terms of not having, for the arbitrators, not having to travel from point A to point B. They do create certain advantages in trying to assemble everyone in the same play at the same time. But they also bring an element of uncertainty. Like Richard mentioned the point about the bundle of evidence being presented to the witness from behind the scenes. Then again, you do not feel what the arbitrators are listening. You do not feel the feedback, and that is very important, particularly if your argument is difficult and you have to deal with it. And in my experience of rapping at arbitration hearings, I mean, I had 2 very different cases just for the sake of it. In one case, we were supposed to have an oral hearing, but unfortunately it was getting postponed further and further. So instead of a hearing in March, we ended up having it postponed until summer. Then in summer it didn't work. We managed to get it postponed to December. And then in December, it finally appeared that it would be very difficult for the board members to travel. So we have ended up from a position when we needed an oral hearing to the position when the board eventually decided to decide the appeal on papers. It was a very big case with a lot of documents. So I think in that particular case, we would actually benefit from having a hearing and trying to explain it to me. But again, it is the decision of the tribunal, of the board, how they want to proceed with it. And again, the difficulty is when the documents move back to papers, you are in the hands of the lawyers who otherwise wouldn't be able to represent the parties at the hearing. So instead of a position where I would be placed against another trade rep, a person from more commercial background, less legally skilled, etc., I am now against the QC who will be drafting concluding submissions. So again, for the purpose of trade arbitration, I think it kind of slightly affects the balance, and we need to be careful how we approach it and what we do with it. Again, a different situation. We were not supposed to have any oral hearing at all. There was a decision that appeal would be taken on documents only. And then suddenly the lawyers started pushing for hybrid case management conference, which ended up in instructions for almost like a quasi virtual hearing, which we received a notice of 2 weeks before it. So again, even though technically it was not a hearing as such, we have ended up with a virtual oral hearing with some, without some usual attributes which would help us to preserve our position. And we ended up with an oral hearing because the board decided they wanted to ask some questions. So again, this, the need for having the ability of having this virtual conferences or meetings now, it almost like it opened a certain Pandora box in my view, because one thing when you have certain opinion and certain idea that you're going to have a hearing, you have all the arrangements, you have all the rules, everything is well organized and well working. Another one, when you suddenly start introducing the hybrid options, and say from what I've heard from my colleagues in GAFTA circles, they do not really like the idea of a hybrid hearing when some members are present in the room and some board members are outside of the room. So again, all these little things, they may become very relevant. And even though we have a very small proportion of cases with oral hearings, if you need one, then you should be very careful in planning it. And you do need to make sure that your position, that you're not facing something you don't like and you don't want, and you need to make your position very clear to the tribunals who will be dealing with your oral hearings. Two more things which became slightly different from what it used to be. When we talk about submissions of documents and bundling, of course, all the submissions are now being served electronically. Unfortunately, because of the volume, sometimes we do need hard copies. So the only difficulty was when GAFTA had to be in the lockdown themselves, and all the submissions would have to be arranged to be sent directly to arbitrators. But again, GAFTA addressed this challenge quite well. The arbitration team is very efficient, and that issue is not an issue anymore. The only thing is that if you know that you are sending your submissions electronically, always double check with GAFTA and the members of the tribunal whether they would require hard copies, just for convenience. And the final point, of course, with the move towards virtual documents and everything, we now all sign documents electronically, which can be signed by signing and scanning, which can be signed via PDF functions. So for your purposes as lawyers, if you know that you need a hard copy signed award for enforcement purposes, you do need to make sure that you notify GAFTA accordingly, that you notify the arbitrators, and that could be arranged, because as the rule of thumb at the moment, all the awards are being signed electronically. So that's pretty much everything I wanted to say, unless we have any specific questions. Igor, do I have time for a bonus track?
You have two questions.
Oh, we have questions. Oh my goodness me, I wasn't ready for the questions. Okay,
very very easy. Elena Kalinowska asks, what platform does GAFTA use for oral hearing?
It's Zoom.
Zoom everywhere.
And
anonymous participant asks, will the number of Ukrainian-related GAFTA arbitrations increase in 2021? How do you think?
Okay, that was actually the question which I had on my bonus track, so I'll quickly deal with that one. Those people who work with Black Sea as much as I do, we all know that Ukraine had suffered a bit of a bad harvest situation. And as a result of that bad harvest, there's been a number of increasing cases of farmers not performing their contracts. There's been a lot of discussion about it generally in Ukrainian trading circles and international trading circles. And while the common consensus is that the parties will end up sorting their issues more or less amicably, there's the likelihood is that there may be some cases that will end up in arbitration. Of course, to say that GAFTA is going to be full of Black Sea cases again in 2021, of course, some cases will end up in GAFTA. Hopefully not as many as we expect them to be, because again, we all know that trade goes in cycles and we've had difficult years before. Some parties managed to survive those years better than the others. Some parties went bust. Some parties managed to had difficult trading years, but then managed to bounce back. So I do hope that from the trading perspective and from the commercial business perspective, the parties will manage to find solutions to the problems. But of course, I would expect, well, this year compared to the previous year, the statistics was a little bit down. So we had about 25% decrease of overall cases. But I think next year we will at least be back to the usual numbers of something under 400 case claims. And again, it's a question of how the parties will decide to deal with it. And again, just a final point, a final comment, GAFTA and COVID-19. I'm afraid that generally, if we look at COVID as such, GAFTA has GAFTA prevention of delivery shipment clause, which is again in all GAFTA contracts. So you will have to look very carefully into your contracts and in the relevant circumstances. And of course, we can talk a lot about what can, what may, what could potentially constitute COVID-19. But for me, it's a very simple three-figure thing. First, there must be an event. Second, there must be an impossibility to perform. And third, there must be a connection. And you are the ones who will have to prove on the facts the connection. Because if there's some sort of pandemic, but your issue is bad harvest, which affected your yields, and you as a farmer cannot perform the contract, I'm afraid this is unlikely to be fallen into any kind of force majeure categories, etc., etc. Again, if anyone has any questions, you have my details, so feel free to drop me an email and be more than happy to help.
Thank you, Ivana. Thank you once again. It's getting, dark outside here in Ukraine, but it's early morning in the United States. And let me welcome our last participant, our last speaker, George Charles. George, are you here with us?
I'm here. Can you see me and read me?
Yes. See you. Did you have time to drink your morning coffee already?
Not yet, and it's still dark here.
Okay. So the floor is yours. You have a lot of time. Nobody can stop us now.
Well, that's wonderful. No, my presentation will be short and sweet, I hope. Let me please bring up my PowerPoint.
Yes.
Has it come through on your side?
Yes, great.
Okay. So good afternoon, everyone. It is wonderful to be able to see so many familiar faces. It's been a long time where we've been working by ourselves in our basements, and boy, has it been a sad time. But today, I'm going to make a short presentation on what's happening in the U.S. litigation and arbitration space during this pandemic. And as you'll see by the opening slide, even Lady Justice has to wear a mask when she goes to the courthouse. To understand what's happening, you have to have a little knowledge of our system. Everyone's heard about the U.S. Supreme Court. Of course, it's been in the news lately with all the political maneuvering between the two prevailing political parties in the U.S. But we have parallel systems. The United States is made up of 50 states, and every state has its own state court system. Of course, on a parallel track, there's a federal court system throughout the United States that goes to a circuit court for appellate matters and then up to the Supreme Court ultimately, if accepted. What you may find to be tremendously amazing, but even more so frustrating, that there is a total lack of uniformity on how the courts are dealing with the situation. And what we've seen is some courts have been very user-friendly and business has been not quite as usual, but moving forward, yet other courts have been at a total standstill. That, of course, is fueled by the political situation. This is a map of the United States, and it's not an election map, which you may have seen on international news channels. This is a map which identifies who's in charge of the state, who's the governor. The Reds are the Republicans, the Democrats are the blue. And during this pandemic, the political response has been diametrically opposed. In the Republican states, the Republican-controlled states, the general conventional wisdom is business has to continue, life has to go on, we'll all take a risk, but we'll do our best to mitigate those risks by washing our hands and wearing masks and staying home, except for non-essential things. In the Democratic-controlled states, it's been quite the opposite. It's been doom and gloom, and everything is shut. New York is shut. California is shut. Business is at a total standstill, and it's really starting to be a problem. In response to the pandemic, it took some time for action to occur on this side, but as of March 11th, 2020, most courts were fully shut. Some remained open only for emergency business that could be done by electronic means, but almost every litigation matter was adjourned. If you had a hearing, if you had an appearance, if you had an oral argument, it was adjourned. First put off for 30 days, then put off for 60 days, and then the summertime came. So then put off till September or October. And then as September and October came around, the court started to do business again, but not business as usual. There was some efforts to make phone conferences, but the technology in many of the courthouses was not sufficient and didn't have adequate capability to do it properly. So then the shift to video conferencing and Zoom-based platforms or WebEx or Cisco system platforms came about. And that was okay, but not without its problems. In fact, there was a lot of problems, at least in the beginning, and they still persist today. For a short while, last month, October, turning into the beginning of November, some of the courthouses started to reopen. But as the matter has evolved and the numbers of infections during what's been called a second wave have been spiking, those courthouses have generally been closed down for outside business. Some judges go in, some court staff goes in, but for not generally open for the public. Nevertheless, there are some hearings being held and some trials being conducted, some with success, many without. At the moment, the preferred manner and means for court business to be conducted is through virtual proceedings, and it's generally through video conferencing. Hearings, depositions, mediations, conferences, and trials all are going forward, not nearly at the same rate that they would in ordinary times, and not nearly with the same degree of successes. Early on, many judges were dissatisfied with what was happening on the video conferences, and I share with you an excerpt from an order issued by Broward County Circuit Judge Dennis Bailey. And when he was very frustrated with the lack of professional conduct by the lawyers and the advocates who would be appearing in his court virtually. And he wrote, and I shall read it, "It is remarkable how many attorneys appear inappropriately on camera. We've seen many lawyers in casual shirts and blouses with no concern for ill grooming, in bedrooms with the master bed in the background, etc. One male lawyer appeared shirtless, and one female attorney appeared still in bed, still under the covers. And putting a beach cover up won't cover up your poolside in a bathing suit. So please, if you don't mind, let's treat court hearings as court hearings, whether Zooming or not. And of course, that's a notice to the bar put out by a prominent judge. Recognizing that once the courts reopened for business and new filings were being made and new lawsuits were being commenced, the backlog of cases grew very quickly. And so what was happening, and what still is happening, is that the courts are referring cases out for virtual mediations and settlement conferences. If you're not in a position to speak meaningfully or productively about resolution, then the court authorizes and directs the parties to go forward and do some minimal discovery, generally speaking, an exchange of documents and some depositions, also to be taken through virtual means. The court staff doesn't have to be present. The attorneys can do it from home. The witnesses need not travel. And the court reporting services and the videographers are making a killing doing this. All of the court reporting services are offering what they term to be their proprietary platforms. They all use the same sales pitches that were available 24/7, 365. We have super performance, we're flexible and easy to use. It will be your best experience yet, and you can present your documentary exhibits very easily. Of course, you can also present video clips and movie clips and things of the sort and demonstratives. But this has been a boom time for the court reporting services, shifting from the traditional, let's go to a conference room or let's go to the courthouse and record the proceedings, to I'll stay home and do it on the internet. As the courts have opened up and people have had to come into the courthouse, there are procedures to be followed. Many things can be done virtually, but not everything. I'll share that in the maritime space, there have been, I believe, 2, possibly 3 judicial sales of vessels after an arrest or an attachment. And in fact, there's even been virtual ship auctions that have proceeded and proceeded well. But to go into the courthouse, what to do? The Southern District of New York, the federal court sitting in downtown New York City, is a leader. They've prepared a QR code that you basically scan with your mobile and then answer some very basic questions. And it's an honor system, if you will. Have you been near anyone who's tested positive? Is anyone in your household testing positive? Do you have a fever, a cough, shortness of breath, nausea or vomiting, or all the other symptom check type questions? Once you pass the test and you submit your QR code, you'll have to pass through a thermal scanner for a temperature check. Again, if you have any of the traditional symptoms, cough, shortness of breath, fever, or chills, you're denied entry. But assuming you're permitted to go forward, masks are always required. Social distancing is supposed to be maintained, at least to the extent possible. Generally speaking, in the federal courthouses, there's lots and lots of square footage, so that's not such a challenge. In some of the state courthouses and county courthouses, it is a much bigger challenge, which in turn has led to those forms being very, very poorly running at the moment. Once inside, there are many, many signs and posters to remind you, maintain your distance, wear your masks, and of course, many stations where you can take hand sanitizer and wash your hands. One of the big things we hear, I think everybody hears around the world, is wash your hands and wash your hands often. If you were so lucky to actually get to a proceeding, the courtrooms don't look anything like they used to. The witness box chairs are spread out at least 6 to 10 feet apart. There's plexiglass barriers between all your jurors, and if you were to call a witness to testify, they too would be behind a protection screen, a plexiglass screen, and be required to wear a mask. Of course, the wearing the mask part can be problematic because you lose so much of the nonverbal cues and the nonverbal testimony by observing the witness's demeanor and body language. Some courts have conducted jury proceedings in those very few matters, each of the jurors are given what they call a goodie bag, which is personal protective equipment, masks and sanitizer and gloves and disinfecting wipes and some thermometers that they can take their own temperature during the day. And again, the name of the game is social distancing. In New York, there's been precisely one jury trial, one criminal jury trial since the beginning of the pandemic, which is amazing because there are many, many, many jury trials going on simultaneously when the court is operating normally. In this matter, 2 individuals were being prosecuted by the Department of Justice. And prior to the trial going forward, both defendants, through their counsel, raised the argument that, hey, we can't go forward at this point in time because we won't have a fundamentally fair trial. People will be too worried about their own health and safety and distracted from watching the evidence. So the judge says, no, that's okay. We'll ask a couple questions during the jury selection process, and we'll ask whether serving as a juror during the pandemic will prevent you from being fair and impartial and attentive. Who's going to say, yeah, it will? Well, apparently some people did say that, but a jury was impaneled. The case went forward, and ultimately, all the challenges that were raised by the defendants were rejected by this fellow, Judge Jed Rakoff. Now, I say Judge Rakoff, and I include his picture because you'll remember Judge Rakoff. He's famous. He's the guy some years ago that decided the Jaldi case, which said no more Rule B attachments of electronic fund transfers passing through New York intermediary banks. For the international maritime law community, the Rule B attachments of US dollars coming through New York was a great thing. It was a means to obtain security for maritime claims. It was a means to obtain quasi-in rem jurisdiction when necessary. And at one point in time, there were billions with a B, of US dollars under attachment at New York-based intermediary banks, until, of course, Judge Rakoff said, no more of that. Ultimately, as could be predicted, the jurors were inattentive, more or less. They wanted to get out of the courthouse as quickly as possible. They convicted both of the defendants, and now the matter is set for sentencing in February of 2021. Now, that's potentially problematic because just last week, the Southern District of New York suspended all in-person court operations until at least January 15th. On my slide, I wrote until January 15th, but it really should be written as until at least January 15th. That's an outlier. Almost every other federal court has suspended operations through March of 2021. All jury trials are adjourned, whether they be civil or criminal. There is an ambition to conduct bench trials and hearings remotely, but it's an ambition. It's far from the reality of what's happening. And of course, the problem that we have is our criminal system provides the right for prompt hearings for defendants, right? They come in for an arraignment, they can proceed very quickly, but there's a real problem. And the real problem is what to do. If you can't come to court, how do you give these people their due process? There's an expression that says justice delayed is justice denied. So the courts have been trying to prioritize the arraignments and some of the non-essential, the non-dispositive criminal proceedings through remote means. Now, a parenthesis to the story. What happens in the case, like we saw the 2 executives that got convicted of fraud? What happens now at sentencing? Where do they put these guys? The Bureau of Prisons has had numerous outbreaks of COVID, and they cannot keep the prisoners safe. So in turn, many criminal defense lawyers have made applications to courts asking for early release, particularly of white-collar nonviolent offenders. And in many cases, in fact, I'd say most cases, those applications have been granted. In more liberal jurisdictions like New York and New York City, even the violent offenders are getting let out of prison early and without supervision. So it's kind of a funny time here. Finally, I'd like to visit about arbitration. One would think that if you had matters that are in arbitration, that's the easiest thing to go forward because it's by agreement. Both attorneys on both sides of the dispute can sit down and work out a protocol. The arbitrator should be commercial and user-friendly, and virtual means should be a home run for proceeding in the almost ordinary way. But the reality is that's not happened. I think there's been maybe 1 or 2 cases in which there have been some hearings within the Society of Maritime Arbitrators. And even those hearings have been very problematic for a number of reasons. But primarily, it's a lack of experience and lack of familiarity and a lack of comfort with the technology. The arbitrators are having difficulty. The advocates have complained that they're having difficulty with their witnesses. You don't have your witness just beside you. You can't take a break and have a chat. Very difficult to prepare. And at times it can be a challenge to share your screen and put up your documents and show the parts of the evidence that you want to focus on. And of course, many witnesses don't like it. Now, party witnesses often don't have the ability to refuse to come if they were so requested, but non-party witnesses say, nah, I'll see you in 6 months or 8 months when we can travel again. Also, we've understood some of the, unlike court staff, specific training on the technology. The cases we have many that are at various stages of arbitration, they've all been pushed. They've been pushed for us from the March and April timeframe to the summer timeframe, from the summer timeframe to like now timeframe, and the cases that are coming up for hearings are all being pushed well into 2021. Not great for the law business, certainly not great for the parties who want their dispute to be adjudicated, and I'm sure equally unpleasing to the arbitrators who aren't able to bill their time and collect their fees. And that's it. I would say that the situation in the United States, business is going forward very, very slowly. The law practice is still moving forward, but at a crawl, not nearly what it was. The huge amount of disputes we all expected from force majeure declarations and charter party and other contracts being frustrated has not emerged. I understand that many parties have found commercial resolutions, and fingers crossed, other parties are keeping their disputes on the back burner until they can get to the courthouse or in front of an arbitration tribunal to be heard in due course. And that's it. A final comment as I leave my shameless subliminal advertisement on the screen. Vessel arrests and attachments are still going forward. They're deemed to be very important functions of the federal court. There is ordinarily no requirement to appear physically before the court. All the submissions go in through the electronic filing system. If there is a question by the judge or there's a need for additional briefing, they'll be in touch, usually by telephone. Of course, it's an ex-party proceeding, so it's easy to do. Our experience, we've arrested many vessels and have either attached or arrested many things such as bank accounts and bunkers and cargo in the last 9 months. And all of those proceedings have gone extremely smooth. If you are a claimant and you're looking to secure a claim or to enforce a judgment, good news, this is moving forward and as business as usual. If you are on the receiving end of one of these unpleasant surprises, still good news. The court will hear you and will take your arguments on why the attachment or arrest should be vacated or set aside or the amount of security to be reduced. All these hearings are proceeding remotely, but in the usual way. And that's it.
Thank you, George. Thank you very much. That's now the time to say goodbye, as a matter of fact. I think we conquered all our technical challenges today, and I hope we delivered some useful information for our viewers. I want to thank you all for your time, for your participation. We had an all-star panel today. thank you. I want to say thank you once again to our Ince company for the exclusive partnership of our event. I want to say thank you for our for all attendees or viewers. Of course, all of them and all of you will have the follow-up letter with all presentations and with direct link to the recording. Thank you once again, and hope to see you offline and to see you online the next year or offline the next year. Thank you all.
Thank you.
Bye.